Lordship indulgence.
Yes.
I beg to mention item number 33. In this matter is in the admission column only.
Yes.
So I'm paying slight accommodation from this honorable court. Whether this matter can be upgraded and fixed at 2 o'clock, Lordship. Because Lordship takes motion, then orders and admission. So there is very faint chance of reaching this matter. There is some urgency because we are in the midst of a recruitment process.
What is the matter?
The matter is relating to whether 18-month PLAD is a valid degree or not, and whether the documents we have asked to prove that qualification, whether we can do that or not, whether the state authority has the power to verify whether they were in service candidate while procuring the 18 months PLAD course. It will not take much time though.
Who's for the other side?
Okay.
BC in this matter. All right.
Deeply open.
Maybe. I beg to mention, my lord, an urgent matter for tomorrow as motion, because the medical admission for the second phase counseling has started, will start from tomorrow, and it will end by 4th of, my lord, this month. So the candidate is having the, under the quota of OBC and non-criminal quota, my lord. So my lord, he has not been called for this counseling process, my lord. So much urgency is there, my lord. So let it come tomorrow. As motion.
When did you file it?
Today. It is
Today only you filed and you want it tomorrow. How
Yes.
can that be?
Tomorrow, my lord. Otherwise, my lord, the urgency is there. If the seats are allotted, my lord, he will be deprived of for 1 year, my lord.
When is it going to be allotted? When is it due to be allotted seats?
Tomorrow onwards.
Tomorrow onwards?
Yes, lordship.
So tomorrow is not the last date, isn't
Tomorrow
it?
is not the last date,
Then-
but tomorrow onwards it will be, my lord, allotted. First come, first service, my lord. Who will go?
Let it come on Wednesday, day after tomorrow.
My
Tomorrow the
lord,
hearing date,
little accommodation for tomorrow at least, my lord.
day after.
If the,
Yes, next.
my lord, with regard to item number 32, my lord, similar cases are there. It's fixed on, my lord. The other cases are fixed on, my lord, the 19th of this month, my lord. So I pray for, my lord, listing along with the other case. I'm giving the list, my lord.
List on 19th of September,
Yes, lordship. I'm giving the list.
as paid for by Mr. B. Prakash, the learned counsel for the petitioner, along with so and so. Give the number.
Yes. Obvious.
May I like to mention item number 35, my lord. My lord, Mr. There within is unwell, my lord. He is paying for adjournment for the day only.
Item 35.
Yes, my lord. Contempt case, my lord.
Who is unwell?
J. Avedin, my lord.
Petitioner.
Yes.
Okay,
Only for the day, my lord.
Mr. J. Abedin, learned counsel for the petitioner, is said to be indisposed. As paid for matters have passed over the day.
Okay, back to petition for listing of it. This matter has not been listed since 9 April 2008.
You approach the registry. Okay.
My lord, I beg to mention the cancel matter, my lord, for listing on next week, my lord, anytime.
You also approach the registry.
Ma'am, my lord, I beg to mention item number 37, ma'am. Item number 37, review petition 218. My lord, today I have some personal difficulties. Can it be on, my lord, Friday next month? It may be taken up on Friday. Friday or Thursday?
Friday.
Right.
That's paid for by learned counsel for the petitioner. That's on Friday. Please give the date.
Obla.
It's productive. I beg to mention item number 43 and 44 Lordship. In this matter, Lordship, in the IA, we are seeking correction of the order, Lordship of Honorable Justice Petitioner, order dated is 3/4/2022. And it may be listed in the appropriate section.
43 and 44?
Yes.
Okay. That's paid for by the learned counsel for the applicant. Registry to list this matter before the appropriate date. Item 43 and 44.
May I please, Lordship? Lordship, I beg to mention for listing of an urgent petition on Wednesday, Lordship.
What is the urgency?
Urgency Lordship, he appeared in the recruitment process for PGT teacher, Lordship, postgraduate teacher, Lordship. And he qualified in the written examination. During Lordship document verification, his candidature was rejected on the ground that he has completed MSc in eco restoration, which is not equivalent to MSc botany. He is applied for botany, Lordship. Yeah, but Dibrugarh University, from where he has done the eco restoration, Lordship, it is certified that eco restoration is equivalent to MSc botany.
Okay, what is the urgency?
Lordship, the merit list may be published at any time, Lordship. It is already recruitment process is complete.
Okay, Wednesday,
If merit list is Lordship,
Wednesday.
Wednesday.
Made with the requisitions paper qualified additional affidavit in a motion matter. I think
Which item?
I supply item 53.
Okay. Item 50, you say? 53. Okay,
Additional.
all right.
Could you kindly pass over the item number 1 for the date and maybe fix on 3rd September?
Why do you want it passover for the day?
Some for personal difficulties.
It's not the first time, is it? Is it that case where every time it's listed, you pass it over? What is the reason?
I don't know.
Every time it's listed, you're passing it over. What is the reason? We'll adjourn it for 6 months. If that is the case. As paid for by the learned counsel for the petitioners, matters can be adjourned for a week. Yes,
Okay. Listing of this matter or pension matter, long due pension matter.
you approach the registry for listing, okay?
Yeah, praise the Lord. That's why we have to mention item number 12 and 15 for withdrawal, Your Lordship. Due to clerical error, Your Lordship. Some clerical errors there are in item number 12 and 15.
These 12 and 15 are same case.
Yes, Your Lord.
Then why they are not listed together?
I may be allowed to file a fresh.
You mentioned one at a time. Item 12, you want to withdraw.
Yes, sir. 12 and 15, Your Lord.
What is your good name?
Arif Ahmed.
Mr. A. Ahmed, learned counsel for the petitioner, says that as there are some clerical error, he may be allowed to withdraw the writ petition with liberty to file a fresh.
And 15 also, Your Lordship.
Just a minute. As paid for, matter stands dismissed as withdrawn with liberty to file a fresh. Same order in item 50. Okay,
That legal lordship, I beg to question item number 50 of today's daily list.
item number
50, 5 feet. That's it. On
50.
the concept of the other side, Your Lordship, later may be adjourned for
Why? What is this IA for? You have no idea. Then why you make a mention? You don't know anything. Basic thing you should know before making a mention is what is this case? Why do you want adjournment? What is the reason? And whether you have taken the consent of the other side. These 3 factors are required. Don't simply appear like that, say adjournment.
consent has been taken.
As paid for by the learned counsel for the applicant, matter stands adjourned for a week. 1 week?
2 weeks.
2 weeks, okay. Yes,
Malad, the estimation of listing of the case, Malad, petitioner was a pension holder. The pension was not released, my lord, only because audit report, that was last occasion, it was
Mr. Counsel, you approach the registry, okay?
listing.
For listing, you approach the registry.
Because pension holder, pension is not getting for 24 January, my lord, that is why.
Maybe you approach the registry first. Yes.
On last occasion, Locus, this honorable directed me to obtain instruction, Locus. So I have received the instruction. So I want to bring it with an affidavit, Locus, be better, Locus.
What instruction?
Regarding Locus,
they have filed this petition, Lordship, on the basis of an interim order, Lordship, at annexure D page 51, whereby they were directed to submit the application regarding their qualification, Lordship. They have claimed that they are getting a Hindi Ratnal equivalent to degree, Lordship.
No, that is not the case, Your Honor.
Ultimately, they were permitted to file their application. We have accepted their application, Lordship. And ultimately, this writ petition was finally disposed of, Lordship. This finally disposed of on 9th May 2025. So entire writ petition filed on the basis of an interim order on 9/5/2025, whereby, Lordship, the Honorable Court refused to issue any mandamus and directed the and has kept the entire Lordship the open, giving a Lordship questions whether the degree in question awarded by the Rashtrapati Prasad Committee can be treated equivalent to having Hindi in graduation for the reason of similar qualification being recognized for appointment of Hindi teacher under high school under Assam Secondary Education Promotion Service is kept open. And Lordship,
That is not my case, Your Lordship. Your Lordship will kindly hear me, Your Lordship, first, then hear him, Your Lordship, since I have an interim.
anyway, I have received instruction. I want to file an affidavit, Lordship, in this case.
But by this time, if the results are out, Your Lordship,
No,
the
they have
question
no,
published.
no, Lordship. They have filed this writ petition on the basis of an advertisement dated 19/10/9/2020.
Let me submit, Your Lordship.
That was already
Thereafter,
over.
Your Lordship will hear him, Your Lordship.
Yes, let me hear it.
Yeah.
What is his case?
Lordship, the petitioners, Your Lordship, has not prayed for equivalence of Proveen degree by the Rashtrapati Prasad Committee with the graduation. Your Lordship. What is there, Your Lordship? There was an advertisement in 2020, Your Lordship. In that particular advertisement, advertisement was, Your Lordship, dated 10/9/2020. Your Lordship. That advertisement was not part of this proceeding, Your Lordship, since it is the second leg of second round of litigation, Your Lordship. In that particular advertisement, they have advertised 1,102 Hindi teachers for upper primary schools, Your Lordship. Now, as per that particular advertisement, Your Lordship, qualification required for applying to those posts, Your Lordship, was that, Your Lordship, that the candidate must have Hindi as one of the subject in graduation, Your Lordship.
What post is this? For what post?
Hindi upper primary teachers, it's Hindi, Your Lordship.
India upper primary teacher.
Upper Hindi teachers in upper primary school. Now, in 2020, there was an advertisement, Your Lordship. And in that advertisement, Your Lordship, they have put the qualification as the candidates will have to have, Your Lordship, Hindi as one of the subject in graduation, Your Lordship.
Anyway, please come to your prayer. You're basically saying that in terms of the earlier court's order,
Lordship,
I should be given that.
we should be called for the verification, Your Lordship. Now, Your Lordship will kindly see the order at page 51. This is the interim order my learned friend was talking about. Interim order to come to us. That is at page, Your Lordship, not that, page 29. And relevant part is page 34. During pendency of that particular writ petition, Your Lordship, an advertisement was issued, Your Lordship, in 2021, or 2023, 27/12/2023. And we filed an interlocutory application before this honorable court, praying that we may be allowed to submit our application, Your Lordship. And in this application, Your Lordship, the direction, Your Lordship, will kindly come to page 36. page 35. Accordingly, the present interlocutory application is disposed of by allowing the applicants herein to submit their respective applications in pursuance to the above stated advertisement to the post of Hindi teachers for upper primary schools. In the event the applicants so submit their applications, the respondent authority shall receive the same and would permit the cases of the applicants to be considered in the selection process. The case of the applicants shall be considered on merit, and the marks as scored by them would be kept in a sealed cover. In other words, the result of applicant petitioner shall not be declared without leave of this court. As to the entitlement of the applicant petitioners being eligible to participate in a selection process, further orders as may be called for would be so issued after the stand of the respondent brought on record by way of filing an affidavit in matter of so and so, Your Lord. So, Your Lordship, ultimately, Honorable Court has held that the final order to be passed in WPC number so and so will consider it, Your Lordship. Now, Your Lordship may kindly come to page number 6. It starts from page 51, the final order. It starts from page 66, Your Lord, the operative part.
So what was the decision?
Lordship, Your Lordship may kindly come to para 3, Your Lordship. The case of the petitioners in all these writ petition is that all the petitioners have the qualification of Proveen from Rashtrabhasha Prasar Samiti, and they claim to be eligible to be appointed as a teacher in upper primary school in the subject Hindi. However, their grievance is that such a qualification is not considered to be an eligibility, though the same qualification is recognized qualifications for selection of a teacher for high schools in Hindi Assam. We are otherwise eligible for, Your Lordship, high school Hindi teachers, Your Lordship, but we are not eligible for, Your Lordship, upper primary teachers, Your Lordship, Hindi teachers.
You're overqualified.
No, Your Lordship.
That-
For high schools, we are considered to be eligible, but for, Your Lordship, upper primary, we are not considered to be eligible. Your Lordship. That was our grievance, Your Lordship. Then, Your Lordship, will see the background fact of this litigation is that certain that may be skipped, Your Lordship. Your Lordship may kindly come to para 7, Your Lordship. In this context, Mr. Borthakur Ranat's counsel for the petitioners referring to Schedule of Assam Secondary Education Provincialization 2018 argues that for Hindi teachers in secondary education class 9 and 10, the qualification prescribed is Proveen Ratna in Hindi with 50% marks and having degree qualification in any recognized university. Degree is there, Your Lordship, along with Hindi, Proveen or B.Ed. It is his further contention that the state, by framing aforesaid rule 2018 under proviso to Article 309, had already recognized the Proveen to be a recognized degree for appointment of Hindi teacher in high schools, and therefore there cannot be any ground for not recognizing the same degree in case of appointment of Hindi teachers for upper primary teachers. The state has taken a specific stand in their affidavit of position that the aforesaid prescription of having Hindi as a subject prescribed in the advertisement is in conformity and in terms of NCT notification dated 23/8/2010, by which the essential qualification for being appointed as teachers in primary and upper primary school is mandated. Referring to the provisions relating to essential qualification for being appointed as teachers of upper primary schools prescribed under Assam Elementary Education Provincialization Rules 1977, Mr. Khatonier, Learned Standing Council, School Education Department, Contempt, that it is prescribed under the rules that minimum qualification of a person to be eligible for appointment as a teacher in the upper primary school shall be as per notification issued by the state government from time to time in conformity with the NCT norms. Therefore, according to him, the respondent state cannot be faulted in prescribing a qualification terms in NCT notification. Then para 9, Your Lordship. Countering such argument, Borthakur submits that the NCT notification dated 23/8/2010.
No, just a minute.
Lord.
See, you come to the decision,
Lordship.
don't read all the submissions and all that. There's no point.
No, Your Lordship,
So,
para 10, Your
No,
Lordship. Finding.
what has the court held?
Para
Ultimately,
24, para 24,
No, Your Lordship.
page 55.
From Your Lordship,
come to the operative portion. Don't
First,
read
Your
the entire thing.
I will go, Your Lordship. Your Lordship, may kindly come to para 10 first, Your Lordship.
Why?
That there is a finding here, Your
No,
Lordship.
why are you reading all these things?
No, Your Lordship, that what is our case?
This matter is listed for motion. It's not for final hearing.
Lordship will kindly come to para 10, Your Lordship.
Don't read all the submissions and all
Lordship,
that. What
this is
the
not
point?
submission, this is a finding, your lordship, will kindly see. That I have written, I have read out, your lordship, to place what was my case in earlier round of litigation for that purpose only, your lordship. Para 10, your lordship. In the aforesaid backdrop of prescription of rules, this court having prima facie found force in the argument of Mr. So-and-so, learned counsel for the petitioner, that NCT notification dated 23/2010 nowhere prescribed any additional qualification of having Hindi as one of the subjects beyond BA, BSc degree, and also having a prima facie view of similar degree, that is Proveen has duly been recognized as qualification for appointment of teacher in high school. The state was directed to file an affidavit clarifying the aforesaid disparity. This was the prima facie finding of the court, your lordship. Then your lordship will kindly come to para 14 and 15. What the court has found, your lordship. Therefore, the required qualification so far relating to the present petitioner shall be as per notification issued in this regard by the NCT dated 23/2010, and any notification in this regard by the state in conformity with the NCT notification. It is important to note herein that the enactment of Right to So-and-so Act 2009 NCT was notified as the academic authority in terms of section 23(1) of the Act of 2009 by inserting section 12A of NCT Act 1993. Thus, NCT is a statutorily empowered and authorized to determine minimum standard of education for school teachers in elementary level. Accordingly, NCT issued notification dated 23/8/2010 prescribing the minimum qualification for being appointed as a teacher in elementary schools. The minimum qualification for being appointed as a teacher, more particularly as teachers of class 6 to 8, that is the upper primary teachers, your lordship, which is the subject matter of present writ petition prescribes following.
Okay, we'll do one thing. We'll issue notice. Let him file his instructions. We'll hear you.
Para 22, your lordship may kindly, last part, your lordship, of para 22.
I'm issuing notice.
But in the meantime, if your lordship, they pass this selection list, your lordship, then your lordship, virtually it will become third party right will be accrued, your lordship. That's why,
How soon can you file your instruction?
lordship,
By next week.
Next week.
But
After a
one
week,
thing, yes, by next week, yes,
returnable within a week.
yes, yes.
Heard Mr. S. Kotaku, learned counsel for the petitioner. Issue notice of motion returnable by 1 week. Mr. S.N.P. Chisti, learned standing counsel, second education department, accepts notice on behalf of all the respondents. All the respondents,
Yes, always.
and he also submits that he has received the instructions and he'll be
Yes.
filing his counter affidavit within 1 week.
para 22, your lordship, very clear, your lordship. They have, the honorable court has held, your lordship, that being the position, insistence of Hindi as a special subject in graduation, in absence of any prescription by NCT, or in absence of notification issued by the state in exercise of power under Rule 3 of Rules of 1977, shall be violative of the petitioner's right under Article 14. This is the specific finding of the honorable court.
Since urgency is expressed by the learned counsel for the petitioner, let the
It's
matter.
all right, but para 24.
Let
this
the matter
honorable
be
That is
court
not my
any
case
amendment
at all.
must be-
That is
Let
not
the
my
matter be
case. at
listed
all.
on
That is the
counsel.
different case.
10-9.
Okay.
You file an affidavit, we'll hear
Yes,
you.
yes.
Lords, we'll finish it up.
Deeply obliged. to me.
Your lordship, instruction was called for. The petitioner's case is that he was praying for the service benefit of his late cousin brother, who was a ex-teacher of Bokota Nemuguri High School.
Yes, what is the instruction?
Lordship, one instruction is received, your lordship. I would like to please.
Yes, what is this?
Your lordship, in the second paragraph itself, your lordship, in this connection, I would like to read it.
Read.
It is to be stated here that as per government letter so-and-so dated 18/8/2021, all pension proposal of government retired teachers have been processing in Kritagyata portal
after superannuation that of the government teachers employees through concerned inspector of schools to the director of pension Assam. Therefore, you are requested to examine the matter as the said matter falls under jurisdiction and submit the family pension proposal along with all authenticated required documents to the director of pension, your lordship. It was, your lordship, under the Pritagyata portal, your lordship, and for that, your lordship, they are requested to submit all the authenticated required documents to the director of pension in Pritagyata portal. So, your lordship, it was under process, your lordship. Okay. All right. Okay. Stop.
So how long will it take for processing the pension? How long will it take?
For that, your lordship, because your lordship, they have to approach your director of pension, your lordship, with all the required documents. Once they are, your lordship, examined, that would be same, your lordship, will be uploaded in the Pritagyata portal website. Thereafter, your lordship, director of pension is the concerned authority to give the instruction. Status report regarding the time bound. Party of the director of pension.
This benefit. Don't know, I hit it.
Thank you.
There's some discrepancy in the case number. 468688.
4688.
This is 4684. How many cases you filed?
Typographical mistake, your
The
lordship.
typing mistake.
84. 84 is that 60. Typographical mistake.
So this communication is from the from the
From,
director, debit
from
director
Deputy Director of Secondary
to
Education
inspector of,
to Inspector of the School.
so inspector of school is supposed to take some steps.
He will be the examine the matter, your lordship.
So you file an affidavit. Ms. P. Das, Stamping Council. Secondary Education Department is that he received instruction from the Deputy Director of School Education. And he may be given a week's time to submit our instructions by way of an affidavit. Where is allowed. List again after 10 days. On a date to the pitch
You can take maybe take.
Registry will fix it.
Apply.
Correct.
May I please, your lordship. My lord, the other day, the Honorable High Court was in a position that it is a like PIL. So, writ petition does not lie. And I was asked to show proper citation if necessary. Now, my lord, I have given
So what is your
Check.
case?
case, yes. My lord, there is a school, namely Kaki Tongla Jatiyo Vidyalaya. The school has been established in the reserve forest land. There are several schools and rice mill, and the road is also very small. So students cannot go there easily. As there are forests, so there is also apprehension of their lives. So this present petitioner and another person filed several representations to the authority that school has been established in a forest land, so the permission should be cancelled. And those representations, lordship would kindly see several representations, page 16, page 19, 22, 25. So first representation was filed to the block elementary education officer, that is page 16. Second representation was filed before the inspector of schools. Third representation was filed before the district commissioner Hujai. And after all this, there was an inquiry, my lord. That lordship may kindly see inquiry report page 26. An inquiry was conducted by the authority.
Who is the petitioner? Who are the petitioners?
Petitioner is Jalaluddin.
That is
And-
okay. His name is there, but what is your locus?
That is my role. By Locus, in this regard, lordship, I have brought two citations before your lordship. Kindly see, that is 2002.
No, please tell me who the petitioner is.
Jalaluddin is a leading person of the person and who is connected with social activities.
What is your interest?
My interest is that, but because of this school, my lord, the students are going in between the forest and they have manipulated the documents. It is reflected in the inquiry report itself. For a
What-
moment, lordship, kindly see the inquiry report.
What right of yours is affected by the
Right is affected, my lord, because
by the establishment of this school?
right affected, my lord. There are so many schools at one question.
No,
So many
no.
nearby
What is your
schools.
locus?
My locus, that for locus, I have given two citations.
What is this? This is a writ petition. This is not a PIL.
It is not PIL.
Then
Now, then the PIL, my lord, writ petition is also maintainable. For instance, my lord, kindly see 2002 1 SCC, I have given. Para 38. Para 38. After 5 lines, lordship may kindly see. After 5 lines, para 38. The existence of legal right of petitioner which is alleged to have been violated is the foundation for invoking the jurisdiction of the High Court under the aforesaid article. The orthodox rule of interpretation regarding the locus standi of a person to reach the court has undergone a sea change with the development of constitutional law in our country.
just a minute, Mr. Mahmood. You are reading from which?
Para
paragraph?
38. Well, 2002 1 SCC Ghulam Qadir versus Special Tribunal
Page number.
is the page number 33,
And paragraph 38. What-
paragraph 38. After 5 lines, lordship kindly. Para 38 after 5 lines. the existence of legal right, Lordship has seen,
Yes.
the existence of legal right of the petitioner which is alleged to have been violated is the foundation for invoking the jurisdiction of the High Court under the aforesaid article. The orthodox rule of interpretation regarding the locus standi of a person to reach the court has undergone a sea change with the development of constitutional law in our country. And the constitutional courts have been adopting a liberal approach in dealing with the cases or dislodging the claim of a litigant merely on hyper-technical grounds. If a person approaching the court can satisfy that the impugned action is likely to adversely affect his right, which is shown to be having source in some statutory provisions, not having the locus standi. In other words, if the person is found to be not merely a stranger, having no right whatsoever to any post or property, he cannot be non-suited on the ground of his not having the locus standi. He says that not only affect statutory violation of statutory right. Now, violation of statutory right is this: in forest land, school cannot be established. So this law has been violated. So any person has the right to raise the question before any court of law for such matter. And this judgment has been also followed by our High Court. Our High Court also followed this. That Lordship may kindly see 2013. Our High Court has 2015
No, just a minute.
Guwahati Law Journal.
Just a minute.
That is another judgment, 2013. Yes, paragraph I have given. Yeah.
Print out of what? Print out of what? What is this?
The same principle has been followed by in 2013 by the Honorable Supreme.
This is a different judgment.
Different. Earlier was one 2002, present one which the court master is giving, that is 2013. And my lord, in our case, my lord, only our limited prayer is this: authority may dispose our representation. We don't want more than that.
See, the judgment which you're relying upon, 2002, volume 1.
And 2013 also.
Oh, forget about 13. Let us first deal with 2002. This is something else. It says writ petition can be filed by LOT tenants as well as custodian under the J&K State Evacuees Administration of Property Act 2006. So both have the right by the LOT tenant as well as the custodian. So there's no question of locus standi. Subject is different. Your case is
No,
that in
there
some
is a-
forest area,
there is
please listen,
understanding.
please listen. In some forest area, somebody has got some provisional permission and set up a school. And who are you?
That
Who are you?
Though that permission has been obtained fraudulently, it is reflected in the inquiry report mail. In the inquiry report, that is page 26 or 40%, 27.
You cannot just pick up a particular paragraph and say that this is applicable to my case. This is a different story. Yours is a different story.
My lord, I am on ratio. The ratio laid down. by
Even
the
if you are on ratio, it's a different thing. This is a question between a lottie and a custodian. Supreme Court has said both have the right. Today, you are here before this court with a case saying that somebody has set up a school somewhere. That somebody is running the school with some provisional permission, rightly or wrongly given. Okay. Now, authority has not said anything, but who are you to come before the court complaining that they have opened the school like
I
that?
am satisfied, Your Lordship. There are two questions.
What right has been affected? What of which right, which of your right has been
First
affected?
thing, when a law is broken by someone, any citizen can raise the issue. Number one. So law is broken in forest area, school has been established, and that too by manipulating documents, it is reflected in the.
So you come to the court with a proper proceeding, not by way of a writ petition like this.
Authority is silent, manner. That is the
Maybe
problem.
author is silent. So you come with a, nobody's shutting the door to you. You have to come to a proper proceeding, not just writ petition. You know what is writ petition? How mandamus can be sought. Unless and until your right is affected, you have to say that this person or that person, they are in this place, wrongly there. I should be there or they should be removed.
Then, my lord,
You
I
should
may
have
be-
to,
I may be given liberty to liberty to approach the authority, and authority will consider the
you
matter
withdraw
in
this,
that view.
you withdraw this plain withdrawal, nothing, no liberty, nothing. It's all up to you. Nobody's tied your hands. Nobody's preventing you from approaching any authority.
But my
It's entirely
conclusion is
up to
they are
you.
not doing
But
anything.
a writ petition in such a nature, in such a manner is not maintainable.
And I
I'm
have
sorry.
two judgments, but
But these judgments are not applicable, Mr. Mahmood. Please understand.
well, I am not on facts. I am on law points. Sorry.
I'm also on law
point
point.
say,
Nobody's on facts. facts are completely different.
Yes.
One is facing east, one is facing west. Facts, they're not similar at all. I'm also on the law point. You are talking about the locus.
But law point, if you.
Now, that locus in this case has been established by the Supreme Court saying that they have both have the right.
No,
It's regarding the allotee tenant as well as the custodian.
My lord,
They have the right to challenge this.
if your lordship is pleased to listen me to read the operative portion, few lines. The orthodox rule of interpretation regarding the locus standi of a person to reach the court has undergone a sea change with the developmental of constitutional law in our country. And the constitutional courts have been adopting a liberal approach in dealing with the cases or disclosing the claim of a litigant merely on hyper-technical grounds. If a person approaching the court can satisfy that the impugned action is likely to adversely affect his right, which is shown to be having a source in some statutory provision, that is statutory provision. So statutory provision says in forest area, a school cannot be established.
Please read this sentence. If a person approaching the court can satisfy that the impugned action is likely to adversely affect his right.
Yes.
Likely to affect his right.
Yeah.
Which right of yours is affected? Tell me.
My lord, we should not read only one or two lines. We should read the whole lines, whole paragraph as a whole. That is my understanding, my lord. Here and there we pick up. Even then, if a lordship is not satisfied on these points, I also understand there are some limitations. Actually, it goes like PIL. So in that view, my lord, that may then to liberty to file appropriate case in appropriate forum, that lordship may kindly opt them.
As paid for by Mr. M.U. Mahmood, learned counsel for the petitioner. The writ petition stands dismissed as withdrawn.
I'm appearing for 1, 2,
Mr. P. Das, learned standing counsel, secondary education appears for the department concerned. And Mr. R. Gogoi, learned counsel, appears for the, who is that? Appears for the forest department. And Miss K. Phukan, learned government advocate, appears for respondent number 4.
Keep you.
May I please your lordship?
Yes.
Lordship, the matter here pertains to non-declaration of the computer test, lordship, pursuant to a post of junior assistant at Mandakata High School. The advertisement was issued long back in the year 2015, lordship. The petitioner is a candidate for the said post, and lordship had heard the matter once. In page 63, there is an order. Lordship had passed an order. Page lordship 68. I'm sorry, lordship. Page 68.
In this matter, your lordship, secondary elementary name has been reflected in the cause list, where it should be secondary education. Element education name has been reflected.
Lordship had got to page 68. There is an order, lordship.
Yes, what is this matter?
Lordship, the matter here, lordship, the petitioner is a candidate for the post of junior assistant, lordship, the Mandakata High School. Firstly, the written examination was held, and thereafter oral test was held, and then the computer test was also held. But the respondents are not inclined to declare the result of the computer test, stating that there are certain anomalies, lordship, in the said test. Lordship, the petitioner had earlier filed a writ petition for null declaration of result, and this honorable court was pleased to dispose of the same by directing the inspector of schools KDC to make an inquiry as to whether there were any anomalies in the said computer and typewriting test. That order is at page 57, lordship.
Page?
57.
starts at page 57, Lordship.
Yes.
The operative part is at page 59,
Same petitioner.
Lordship.
After that, what happened?
Lordship, Lordship, they had, the respondents had not declared the result, Lordship, and the petitioner had preferred contempt. That is also still pending. Lordship, during pendency of the contempt petition, the respondents had come up with a letter for re-advertisement of the said post. Lordship will find that in page 63, Lordship.
Yes.
Lordship, they have stated that the inspector of school, SMDC of the said school, requested for re-advertisement of the said post. Without stating anything, what were the anomalies and what not, they have come up with a re-advertisement, with a decision for re-advertisement. That was put to challenge in WPC number 2895. And Lordship was pleased to grant status quo, Lordship. That page 68 order, Lord.
Then?
Thereafter, Lordship, during pendency of that petition, Lordship, the respondents have come up with the impugn order that we have challenged in the present case. Page 65 is the impugn order,
65.
Lordship.
Yes, what does it say?
Lordship, Lordship, the order portion, the last line, I'll read from there, the operative part, that the record reveals that anomalies are found in the said selection process of recruitment of junior assistant in Mandakata High School, and guidelines were violated as prescribed in OM number so-and-so dated 29/12/2015 for recruitment of junior assistant in provincialized higher secondary and high school and high madrasa. And whereas paragraph number 6 of OM dated 29/12/2015 violated, where it was quoted, in no case will a president member of the selection committee participate in the selection process if any of his or her close relatives are involved as candidates in the process. In such cases, the inspector of schools concerned will nominate suitable alternative. The record further depicts that one candidate was the son of the president of the selection committee, and hence anomalies are found in the said selection process of recruitment of junior assistant in the Mandakata High School. Moreover, the result of the written test yet not declared, as selection committee did not accept the merit list and never signed the written test merit list. So the result of the computer test merit list cannot be prepared for appointment to the post of junior assistant in accordance with law for Mandakata High School. Now, Lordship, firstly, they are stating that there has been anomaly with regard to that the president of the son of the president of the selection committee participated in the selection process. Now, Lordship, with regard to this, an affidavit in the first round of litigation was filed by the headmaster, who is a member of the SMDC, that I have annexed in page 73.
So this order was brought into, it was last time produced.
Lordship,
Correct.
that was produced, Lordship. They have,
Today you have challenged it.
Lordship. This is a
So what to do now? We
Your Lordship,
notice.
Here, Your Lordship, I would like to state it that one affidavit has already been filed, Your Lordship, pertaining to repetition number 2 filed by the same petitioner, Your Lordship. Grievance is almost same, Your Lordship. And here, there in that affidavit in opposition, our stand is there, Your Lordship. We already stated it, Your Lordship. So, Your Lordship, this is more or less, Your Lordship, same, arising out of same.
Lordship,
Because we already stated in our affidavit in opposition.
the impugn order was brought into record. We have challenged in this petition. Lordship, now the stand they have taken that there were anomalies that was already clarified in the earlier round of litigation, the first round of litigation, that Lordship will find it page 73, that they have clearly stated operative parties at page 75, paragraph 7, Lordship. First, they have stated that no member of the selection committee will participate in the selection process, Lordship.
There they have categorically stated by the headmaster of this SMDC.
What is this affidavit?
Lordship, in the first round of litigation, the selection process was put to challenge by some other candidates. This 1451.
So we'll do one thing, we'll club it together with the
Yes,
other case.
Lordship. Till then, Lordship may stay the impugn order, Lordship.
Your lordship,
There is already an order.
already our
status-
affidavit is already filed, your lordship.
There is
So a
already an-
short date may be given, your lordship.
Lordship, in that matter, status quo has been granted.
Exactly. So
Lordship.
will that not cover your case also in this case?
Impugn order has been issued, Lordship. That is, it is a fresh impugn order of this year,
No,
28.
this impugn order is dated February.
Lordship,
It's not that yesterday it was issued.
Lordship.
February.
Lordship may take up the matter together, Lordship, and status quo may be maintained.
On earlier cases, your lordship, status quo granted, your lordship.
What is your good name?
Miss A. Talukdar, Lordship.
We heard Miss A. Talukdar, learned counsel for the petitioner, who submits that by filing this petition, the petitioner has challenged the order dated 28/2/2025, bracket NHR. By which the selection process of recruitment of junior assistant in Mandakata High School is directed to be conducted afresh. Full stop. It is stated the bar that a similar writ petition has already been filed by the petitioner. That is WPC number 2895 of 2025. Wherein parties have been directed to maintain status quo as per order dated 25/6/2025. Next para, in view of above, issue notice of motion returnable by 3 weeks. It's P. Das, Lanet's standing counsel, Secondary Education Department, accepts notice on behalf of respondent numbers. What is the respondent number?
I'm appearing for respondent number 1, 2, and 3.
1, 2, and 3.
There is a private respondent is also there, your lordship, 4.
Petitioner to take steps for service of notice upon respondent numbers 4 and 5 by registered post. They read it within 3 days. List the matter after 3 weeks along with WPC number 2895 of 2022.
That should be clubbed, your lordship, along with the.
Club.
Yes, I'm deeply.
Sort of the status quo order will operate for both the matters.
One matter you have already filed.
Matter.
Status quo is there, then suffice.
Lordship, Lord. Much obliged, Lord.
May I appeal, Your Lordship? So this is second round of litigation, Lordship. So during pendency of the earlier round of litigation, Lordship, matter pertains to Lordship compassionate appointment. And during pendency of the earlier writ petition, the district level committee, Lordship, recommended my name. That Lordship will find at page 32. So copy is not very legible. Serial number 8, page 32. Mausomi Purkayastha, Lordship.
What is this compassion appointment?
Lordship,
What kind of case is this?
compassionate appointment, Lordship. Lordship, my case is that, Lordship, although the district DLC has recommended the name of the petitioner for the post of assistant teacher, but in view of the notification of 18th-9 of 2024, the matter is now placed before the SLC law. That is my case. And subsequently, Lordship, on 30th, a notice issued from the Personnel B department where I may be allowed to place that notice. It said that, Lordship, the candidates of the pending cases, they are requested to, this was published on 30th of August, Lordship. They are requested to submit the particulars in the details. And Lordship, kindly see the serial number 1, 2, 3, then 11. 10 and 11. Date of filing of the court case challenging the WM dated 18/9/2004 and date of disposal of this challenge of the Honorable Court. And 11, certified copy of Honorable Court's judgment and order to be enclosed. This is meant for the candidates where their petitions are pending. Now, this should be we have filed by the end of 15th of September 2025. So, Lordship, my submission in view of this notification, my case may be remand to the SLC, Lordship, and let me consider. In the meantime, we will submit all the necessary particulars. And similar nature of petition has already been disposed of. I have annexed a copy of the red.
But do you, if this notice is there, do you require a separate direction from
No,
this
it
court?
say that is why, Lordship. Serial number 11.
You are at liberty to go. and-
No, certified copy of the Honorable Court judgment to be enclosed. That is one. Serial number 11. These are the requirements. Serial number 1 specifically stated, certified copy of Honorable Court's judgment / order to be enclosed. And we have to submit these particulars by 15th of September. And after that, Lordship, no application will be considered. That is also written here. Lordship, may I read the last paragraph? The required documents, information as per this notice shall be directly delivered, submitted in the office of Secretary to the Government of Assam, Personnel Department, Assam, Secretary so and so, by registered post on or before 15/9/2025. The receipt of such application in the side office at a later date, then mentioned above, will not be considered. And already looked at similar nature of treatment disposed of in view of the order of 5th of.
Yes, who's appearing? What do you say?
I have the notification. I have to print it out here.
Which notification?
Just 30th of August. I have supplied a copy.
It's here.
This is a paper copy.
It was published on 30th of August.
What is the date?
30th August, Lord.
30th August.
Yes, Lord. So, Lord, the
Notification is-
candidates whose cases are pending for consideration before the SLC. So in view of this notification, as well as the Honorable Court's earlier order dated 3/4/2025, we are supposed to submit all these particulars. Now my submission is the Lordship may dispose of with a direction to submit all the necessary particulars before the 15/9/2020.
See, that's what I'm telling you. There's no direction, separate direction required from this court.
No, I am Lordship, that certified copy of the Honorable Court's order.
Certified copy of which order?
This one, certified copy of the.
Which
Lordship,
order? See, earlier you had come before this court,
No, yes, that is pending, Lordship.
2599.
25,
That is your case.
2599, yes, Lordship. During
2599 of 2023.
23, so during pendency of the petition, Lordship, my application has been considered by the DLC and DLC accordingly recommended. That recommendation, Lordship, will find at page 32.
No, what has happened to this 2599?
That is still pending, Lordship.
Still pending.
Yes, Lord. Because so far in my case, Lordship, there is no court order, Lordship, disposal
Mhm.
order.
So in view of this notification, I'm supposed to file this certificate copy of the order. So that is why my submission is.
No,
that-
see, the thing is that during the pendency of a writ petition 2599,
Yes,
you have been recommended.
recommended. Serial number 32, Lord.
So that writ petition should be disposed of. Why did you file a separate writ petition now again?
No, there, in the meantime, also that notification of 18/9 Lordship come to issue. So challenging that 18/9 2000.
89 has come, but then 89, now this notice has come up now in the
Lordship.
newspaper.
So challenging that.
So you have to just submit your details, that's all.
Come to. Or Lordship may list that the petition 2599 by tomorrow or Wednesday. So both the matter trigger and dispose of Lordship on Wednesday, Lordship.
Your lordship,
What do you say?
notification is in my mobile, your lordship.
But there is no any,
You can go to
there is no impediment, Lordship.
Which notification?
that notification.
Ah,
That notification is here, your lordship. I have to print it out, your lordship.
so you want me to see your mobile?
No, your lordship.
Then?
Just I'm
The same
saying.
way
It is already here.
It is widely
yes,
published,
yes.
Lordship.
Why do you want me to show your mobile?
Just I'm saying, your lordship.
There is now not no impediment.
Can it be disposed of in that line?
Yes, yes.
Even
Heard, Mr.
A Decca, Lordship.
A. Deka, learned counsel for the petitioner who submits that the petitioner's father was serving as head teacher of 304 number Sopanpur LP School under the administrative jurisdiction of the District Elementary Education Officer, Hailakandi. And he died in harness on 2/2/2014. Of the petitioner being the daughter of the deceased government employee, submitted her application for compassionate appointment on 28/10/2014 before the Block Elementary Education Officer, Katli Chera. Stop. Since the application of the petitioner was not being considered, the petitioner filed WPC number 2599 of 2023 before this court. And during the pendency of the writ petition, the district level committee, Hailakandi, which held its meeting on 19/9/2023, recommended the petitioner for appointment to the post of assistant teacher in middle schools. And the name of the petitioner appears at serial number 8 of the said meeting minutes. Stop. However, in the meantime, the state government issued office memorandum dated 18/9/2024 notifying that henceforth there shall be no compassionate appointment in view of the introduction of compassionate family pension scheme. Who stop agreed with the same, the petitioner has filed the instant petition. Next para, the learned counsel submits that similar other persons had approached this court seeking for a direction for appointment on compassionate basis. And this court, by common order dated
3/4/2025
3/4/2025,
in WPC number 342 of 2025 and connected with petition. In the notice, it is not referred to.
in passed in WPC number 342 of 2025, connected with similar other batches of writ petitions. Directed that all pending writ petitions, all pending applications for compassionate appointment be considered by the state respondents
By the SLC Lord, page 44. Right, sir.
in the state level committee on the basis of the relevant guidelines in this regard. Most of the learned counsel submits that the case of the petitioner is also squarely covered by the said decision. Woodstock, he also submits that pursuant to the said decision, the state government in the personnel department, they have come up with a notice dated 30/8/2025 by directing all similarly situated applicants to submit their details to the office of the secretary to the government of Assam, personnel department, on or before 15/9/2025. Most of the learned counsel thus submits that the petitioner may also be allowed to submit his details for consideration. Stop in view of above, the writ petition is disposed of by directing the petitioner to submit all the necessary details for considering his appointment on compassionate basis before the authority concerned in terms of the notice dated 30/8/2025. Writ petition stands disposed of.
Your Lordship, I'm referring
This
to-
notice may be kept as a part of the record.
2025 is retained in record and marked as X. for a page.
Mablan,
Your Lordship, I'm for reference number 1, 2, 3, and 6.
Miss
K. Fukan,
A. Fukan, learned government advocate, appears for respondent numbers
1, 2, 3, and 6.
1, 2, 3, and 6. And Miss N. Fukan, learned standing counsel, secondary, elementary education department, appears for respondent number 4 and 5.
Okay.
Biplab.
May please your lordships.
Yes.
My lord, this petitioner before your lordships is a grade 4 employee lordships, and he is working in SBMS College, Swalkusi lordships since August 2024 lordships. Now lordships, prior to that lordships, from 2012 to 2024 lordships, for 12 years, he was working in DK College, Dakshin Kamrup College, grade 4 employee, laboratory bearer, lordships. Lordships, this appointment he got on compassionate ground, lordships, at SBMS College, Swalkusi, lordships. Now one Harkanto Teka, lordships, he got retirement laboratory bearer on 1st March 2025, lordships. And since 1st March 2025, as on today, lordships, that post fell vacant at DK College, lordships. Now these students of DK College in botany department, lordships, they are suffering due to non-appointment of laboratory bearer, lordships. Now the petitioner has approached before this honorable court seeking a direction that you may please be transferred from SBMS
Controlling authority that will transfer you from one place to another place.
lordship,
Who will transfer you?
lordships, in the interest of the students, lordships. And also, lordships, her mother is suffering from uterus and ovary cyst, lordships. And as she is living alone and her helping hand is necessary all the times. So in the interest of natural justice and also in the interest of students' lordship, accordingly, this petitioner has approached as a post fell vacant, lordships. A post
So you approach the respondent authority. If post is vacant, you go and approach the authority, transfer me there. What can the court do?
otherwise, lordships may pray that direction may please be issued that petitioner
no,
will
no.
approach before the competent authority.
No such direction is required. You go on your own. It's up to you. Tomorrow you will go to the authority, see, court has directed you. Consider my case. You consider. That is not the way. You go and approach on your own. Why do you require the court's order?
Lordship, at this stage, lordship, may I pray that notice may please be issued.
This is
You withdraw and are dismiss it.
non-maintainable because then the paragraph 15 there's a demand justice, nothing, that then they're not approach the authority law. There's the first approach, then come the court law. And which is non-maintainable law.
You withdraw.
With a liberty, lordship. I will file the
As
representation.
prayed for by Mr.
R. Sharma.
R. Sharma, learned counsel for the petitioner. The petitioner stands disposed of as withdrawn. With liberty to the petitioner to approach the appropriate authority for redressal of his grievances, if so advised. Mr.
As Bhuya,
S. Bhuya, learned
setting a higher
attorney counsel, higher education,
120.
appears correspondent numbers 120.
File.
Our petitioner, being a science teacher in Jalukbari HS school, has retired from service on 31/3/2025. He has received the pensionary benefit like GIS, leave encashment, GPF, etc. But his pension has not been finalized, madam. And when I file online application to Clerical portal, there is a remarks column that there is some wrong fixation of pay in the year 2011.
Where is that?
Malat page 40 typing and last page 42. Though there is no direct communication to me, but on verification of the status, page 40 remarks. Regarding wrong fixation or excess dwell, I have no control, my lord, because the department has given whatever given, I have accepted. There is no misrepresentation on my part, and I am not aware that there was some excess dwell.
When did you find out this? In excess 7?
My lord, annexus 7 in the month of November, my lord.
November last year.
Yes, my lord. Before,
Have you approached the authority?
my lord, on verbally, I have been in.
Why only verbally?
Yes. Then they can
No
obtain instruction.
no representation is there, your lordship. They have annexed it.
Let them obtain instruction instead of issuing notice, then I will verify what happened. They have not issued any
What
letter.
instruction? No, you've already found out for yourself.
Yes, Malad, there is no.
There's some remark.
Yes, Malad.
First SCPS not admissible as per scale.
Age proof certificate is also not
That has been given.
clarified, Your Lordship.
Yes, book has been given.
You approach the authority, this also. Straight away, you're just filing writ petition like that.
Yes, Your Lordship. They have approached the concerned authority with a representation.
That may be.
But Mr. N. Sharma, learned counsel for the petitioner. No, you write like this. On the prayer, Mr. N. Sharma, learned counsel for the petitioner. The writ petition stands disposed of as withdrawn. With liberty to the petitioner to approach the appropriate respondent authority with appropriate representation within a period of 10 days from today. In the event of filing of such a representation, the same should be considered and appropriately by the respondent authority concerned.
Malad, we did a time frame, Malad.
Who is that respondent authority?
Malad, director, inspector of school and pension, Malad. 2, 3 and 4.
What did I say? Please read. Ten days from today, before the director, okay?
Yes, director and pension and director of.
Time period, Your Lordship.
Before the director of secondary and pension,
Yes,
both.
2 and 4.
Director of pension has rolled, Your Lordship.
It should be one authority, what, two authorities?
Then Malad, 4, Malad.
Before the director of pensions, Ramana Visa.
In party of okay, good.
Then in the event of filing of such a representation, the same shall be considered and disposed of as expeditiously as possible.
That may be disposed of within a month, Malad. I will file within 10 days. They will consider and pass an order within 10 days.
Reason or
By passing reasoned order within a period of 1 month of date of receipt of
And
such a
you-
representation.
1, 2 and 3, sexual education.
P. Sharma, learned, P. Das,
He does.
learned counsel, appears for secondary education department, while Miss N. A. Pukan, isn't it? N. Pukan or A. Pukan? K. Pukan, learned government advocate, appears for the respondent number 4.
I'm deeply aware.
Yeah, Lordship, this matter relates to appointment of graduate teacher in different schools throughout the state, apart from in the provincial system of it. Lordship, kindly see the advertisement, Lordship. The person, page 17, Lordship. Page 17 is the advertisement, Lordship. Page 17. Lordship, serial number 2, graduate teacher mathematics. The number of post is 1737, Lordship. The petitioner being a person with disability, he applied against this post, Lordship. Now, Lordship, admit card was issued, Lordship, and then he appeared.
Which post?
Lordship, graduate, serial number 2, graduate teacher mathematics.
Okay.
Lordship. Person is the advertisement, he applied, Lordship.
How many posts? 1737.
37. Then he applied under person with disability quota, that is 3% reservation, and total number of posts would be 52 against 173 numbers, Lordship. The number of posts would be 52 against this 3% reservation, person with disability, Lordship. Thereafter, Lordship, he applied, admit card was issued, Lordship. Page 21 is the admit card, Lordship. Page 21 is the admit card.
Yes.
Lordship. Now, Lordship, the fact is that admitted position, Lordship, during the verification, my case was rejected by the respondent number 4, Lordship, page 29, Lordship. Page 29, Lordship. Then right side column, last one, Lordship. This is date of issue of mark sheet of D8,
date of passing of B.Ed is after the last date of form submission of TCR 24. Lordship, this is the admitted fact, Lordship. The online application, the last date of online application was, Lordship, 2011-24. This is admitted fact. And when the advertisement was, Lordship, or accept the mark sheet of final B.Ed result, he submitted his application. And that respondent, knowing the everything, Lordship, they issued me admit card and I allowed to sit in the examination. I am successfully passed in written examination. But, Lordship, there is a gap of 26 days, 36 days gap, Lordship. The result was declared, Lordship. Now verification, during this verification, on that ground, my candidates are already rejected. And one more thing, Lordship, after my rejection, I have filed a detailed representation to the Director of Secondary Education, that is page 30, Lordship. Where I have said, Lordship, where I have said, against these 52 numbers of posts, there is only 10 numbers of candidates found to be eligible, Lordship. Still 42 non-eligible candidates are there, Lordship. For those posts cannot be filled up, Lordship. So I have filed a representation, this page 30, dated 30/0/25, addressing to the Director, Lordship. And I have stated everything. My only prayer, Lordship, my representation may be directed to be considered, Lordship, to dispose of, Lordship.
Otherwise,
Yes.
the submission of B.Ed certificate after last date of, yes, Lordship, and Lordship has already issued a detailed order rejecting all those cases.
I'm not asking anything, Lordship, because my case is different, Lordship. There is 52 posts, only 10 candidates found to be eligible in written examination, Lordship, including me, Lordship. Then those cannot be filled up, Lordship, during this percentage advertisement. That is why I filed a representation, Lordship. That may be considered or anything, Lordship, by the Director, Lordship. Only this must be a, Lordship. And Lordship will find, I have given a list, Lordship.
It has already been settled by the Supreme Court that any document submitted after the last date of Lordship, that cannot be considered document. Last date of submission. And that is what Lordship has already issued a detailed order rejecting all those cases.
What is this?
Lordship, kindly see,
Yes,
Lordship.
submitted.
This is the result sheet, Lordship. The cutoff marks of eligible candidate for recruitment verified against graduate teacher, Lordship. Lordship, find the serial number 3, graduate teacher science. I am from serial number Assamese medium. That is 10.50, Lordship. Only 10 was selected out of 3% quota, Lordship. Still, and the 173 numbers of post, Lordship, 3% would be 52, Lordship. Still, posts are required to be filled up, Lordship. And Lordship, the next, Lordship, and second, Lordship,
No, against PWD, there's nothing, it's blank.
yes, Lordship,
No one has been selected.
yes, Lordship.
Candidates will be selected from
So all the 52 all the 52 posts is vacant.
Lordship, that is, I have given Lordship second, Lordship. This is maybe wrong, Lordship. Can you please? I have given wrong. Lordship, page 1 and 2 is there, Lordship. Page and 1 and 2, Lordship.
So what is the difference between these two
Yes,
pages?
this page 1, Lordship, that is 10.50, Lordship. I have marked, Lordship, 10.50. That is 10 is only selected. And subsequent page 2, Lordship, will find, I have marked that there is nothing, nil, Lordship. Second page, Lordship, page number 12.
Yes, what is the second page?
Second, Lordship, serial number 3, Lordship. Assamese, Lordship, in PWD quota, there is nil, Lordship. Now, no one is selected, Lordship.
No, what is the difference between 1 and 2? Why there are two different?
2, Lordship, there is cut-off marks for second and first is, Lordship, and final, 2 different, Lordship. Page 1, Lordship, cut-off marks for second list of eligible candidate for document verification against graduate teachers. So my only prayer, Lordship, there is no eligible candidate is there. Though I have filed a representation, that may be considered and the director can pass any order, Lordship. Only with this prayer, Lordship. I am nothing asking from this honorable court. Only my representation may be considered with the time frame, Lordship.
That direction is not required. They can always consider it without direction. Why do you want?
He has failed in this. Next time they can appeal.
Lordship, I have stated, Lordship,
On the last date of application, Lordship, you are not qualified.
but they have issued the mark sheet, admit, Lordship, allowing, they are knowing that I have not, final result has not been declared, only 36 days gap, they issued the admit card, Lordship.
So,
Lordship, kindly see only for a moment, paste and para 10, Lordship. I have stated.
so what? Because they issued the admit card, it means that this
All
should
those
be given.
questions were raised on the earlier lordship basis where lordship had issued the order, that was detailed order has been issued lordship.
But my case is really different, Lordship.
Why
I'm
they were
against
allowed?
a PWD quota, person with disability. There is no Elizabeth
Maybe,
can.
maybe.
Yet maybe, otherwise that is up to the director, he will consider Lordship.
Maybe you belong to a reserved category, no problem, but thing is that there's already decision from this court.
Lordship, sometime maybe I may allowed to go and next week maybe come, I may go through this decision, Lordship. Only a short
When
time.
after this lordship, other cases also, similar cases already.
I'm
rejected.
closing just now.
Lordship, I am not aware of this order. So by
You
instruction,
should be
Lordship,
aware.
if
You-
the
You'll be aware now. I'll pass the order, you'll become aware, okay?
Lordship may be allowed to withdraw, Lordship, then. Allowed to withdraw. I'll take the instruction from my client, Lordship, otherwise,
But no liberty.
then Lordship short date may be given, Lordship. I may be,
No, I'm disposing it just now.
Lordship may be allowed to withdraw, Lordship.
That's paid for by Mr.
S.U. Ahmed.
Sorry?
S.U. Ahmed.
S.U. Ahmed, learned counsel for the petitioner. The writ petition stands dismissed as withdrawn. Mr. S.N.T. Chisti, learned
Government to the application.
standing counsel,
3929.
secondary education department, here for the respondents. Yes,
Lordship, this is a matter of promotion to the post of headmaster, headmaster of Kamini Sarkar Girls High School. Lordship, I am having all the requisite qualification to be promoted to the headmaster, Lordship. And the management committee has also forwarded this recommended and gave this took resolution for appointment or promotion to the post of headmaster. And but the authority, respondent authority, without following all the required norms, had not allowed me, they had allowed respondent number 6 to be promoted to the post. I have already been handed, the earlier headmaster has already handed over charge to me as per the direction of the respondent authority. I am having the requisite qualification of B.Ed, Lordship. I have passed B.Ed in the year 2008-9, whereas the respondent number 6 has passed B.Ed only in the year 2024, Lordship. As per the Lordship, as per Rule 14, Lordship,
will issue notice,
Lordship, as
will issue notice, Mr. What is your good name?
Darakulla, Lordship.
Darakulla, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the order dated 16/8/2025, by which the respondent number 6, is it?
Yes. Respondent 6.
Has been appointed as the headmaster of Kamini Sarkar Girls High School. Allowed to hold the charge of
Only charge.
headmaster of Kamini Sarkar Girls High School.
Lordship, I have been holding the charge now. The impugn order may kindly be stayed.
Issue notice returnable by 4 weeks. Mr.
My lord, case Chutia.
J.
Number
Chutia.
3 and 4.
Learned counsel appears for respondent numbers 3 and 4. 3 and 4.
3 and 4. My lord, Karbialam Autonomous Council.
Oh,
Under the
okay.
6 it is.
Standing counsel KAC. KAC or KDC?
KAAC, Karbialam Autonomous Council.
Okay. KAAC appears for respondent numbers 3 and 4 and accept notice. Mr. U. Sharma,
Impugn order may kindly be
standing
stayed.
counsel. Secondary education appears for respondent numbers 1, 2. 1 and 2. Petitioner to take steps for service of notice upon the remaining respondents by registered court with their name. Petitioner should also furnish requisite copies of the writ petition to the learned counsel appearing for the respondent. Issue notice on the interim prayer as well, returnable by. Make it 3 weeks of the beginning part of the 3 weeks.
Lordship, look into
you will
annex
order me kindly
page
to-
31, my lord. The response number 6, my lord, is senior, my lord. It appears from the, my lord, annexer 8, page 31.
You obtain instructions on the returnable date, will consider the interim.
He was not
In-
having the requisite qualification, Lord.
Interim prayer shall be considered on the returnable date.
Oblige. Give it.
Lordship, the arguing counsel is on legs on another court, and time being for.
Time being.
The petitioner before your lordship is seeking for pension, family pension, or in alternatively, the compassionate family pension, as well as other retirement benefits like death come retirement gratuity, leave engagement, etc. lordship. Now, if your lordship comes to page 16, which is impugned in the petition, section I, 60. The response number 2, the principal accountant general wrote to the principal Tangla College on 21/5/2025. The subject is, lordship got it, page 60.
Page 60.
60. Last two.
Yes.
Return of family pension case in respect of late Hansraj Limbu, ex-associate professor. In inviting a reference to your letter number so received by this office on 7/5/2025 on the subject cited above, I am to state that on scrutiny of the petitioner's document without submitting service book in original in respect of late Hansraj Limbu, ex-associate professor, is seen that date of birth of the aforesaid incumbent is 1/2/1965. He joined on government service on 7/8/1992 and expired on 5/8/2023. Now pensioner benefits claimed by his sister, Srimati Pushpa Limbu, whose date of birth is 25/2/1964. As per notification number 7 so dated 20/08/2015, major sister brother is not included in the list of family pension of the government servant. As such, this office is not in a position to authorize the pensioner benefit to the sister of the deceased government servant without legally authorized by the court of law. Now, lordship, if your lordship comes to page 40, the present notification, page 40. Page 40 is the notification dated 9th of August 2018. And my brother was unmarried. I am also unmarried though.
Now, what does it mean, this page 60?
Page 60, they have stated that as per circular notification dated 28/2015, I am not entitled. But here at page 40, if your lordship comes to page 40, annex B, this is the notification dated 9th of August 2018.
Page?
Page 40. This is the notification dated 9th of August 2018. And if I may take your lordship to page 42, note number 5. Page 42, note number 5.
Yes.
The eligibility of dependent father, mother, brother up to 18 years and unmarried sister up to 21 years for family pension under the notification number 28/2015 issued by the department is applicable if there is no unmarried dependent daughter or disabled child eligible for lifetime family pension present in the family of the deceased government servant. The above mentioned notification is also applicable in case where the government servant dies unmarried. Here my late brother had died unmarried. And I am only the legal heir. And up to 21 years, it's irrational, not rational. If the motivation says that up to 21
But it says up to 18 years.
18 years for the father, mother, brother, up to 18 years, and unmarried sister up to 21 years.
Eligibility of dependent father, mother. Father and mother, how can it be 18 years?
Yes, Lordship, that is
18
what,
years means what?
that is what this, I am, this notification for. 18 years, how can the father, mother, brother be 18 years and sister be 21 years?
An unmarried sister up to 21
21
years.
This is absolutely irrational.
So you challenge this? Note 5.
And Lordship, if your Lordship comes to Annexure D, page 48, this is the form number 18 has been filled up by the principal of the college. Page number 48. Page number 48, Annexure D, Lordship.
Yes, what is it?
Page 48, Annexure D. This is the letter from the principal on form number 19, along with form number 18 was filled up and was submitted on 3/5/2025. Grant of compassionate family pension and death cum retirement gratuity. I am directed to say that Mr. Hansraj Limbu, Associate Professor, died on 5/8/2023. His family has become eligible for grant of compassionate family pension and death cum retirement gratuity. Form 18 duly completed is forwarded herewith for further necessary action. Government gives in respect of the deceased government servant will be recovered out of the death gratuity as indicated in section 2 of part 1 of Form 18. Your attention is invited to the list of enclosures forwarded herewith. The receipt of this letter may be acknowledged and this department office informed that necessary instruction for the disbursement of family pension and death cum retirement gratuity have been issued to the disbursing authority concerned. And now, Lordship, I am also, my late brother took a personal loan from the Axis Bank. And if your Lordship comes to page page 59. This is the notice from the Lord Judicial Magistrate, Calcutta. Page 59. This was issued on 28/1/2025 after my brother's death. Let's go to page 59.
What is this?
This is the notice from the Judicial Magistrate, Calcutta, Lord.
For what?
Against my brother-in-law. Because my brother took a personal loan and it is here mentioned, Lord. 138 NIS was instituted after the death of my brother, and there are earlier also notices were issued to me, to my brother, late brother. Legal notice was also issued at page 50. So my brother is in debt, has taken loan, and he without liquidating the entire
This
amount.
notice is issued in favor of your late brother.
Yes, Lord. My brother name is Hansraj Limbu.
Okay, but then what about page 60?
Page 60, Lordship. Page 60, they have stated that the notification dated 28/2015, I am not entitled. But whereas the notification at page 40,
Who has applied for the, what do you call, the pension?
I have applied.
Sister?
Sister, unmarried sister.
Whether unmarried sister is authorized?
As per the Lordship, this notification dated 9/8/2018 at page 40.
No, not to, let me place it matter. It is the notification, he has not annexed it. That is the MP order, that notification has been stated matter. Comes under, it doesn't come under the bit of family. Eldest surviving sister up to 21 years of age, 21 years. or marriage, whichever is earlier. So how old is the petitioner? How old is the petitioner?
Petitioner is more than 60, nearing 60.
59 or something.
No, he is
Oh.
20.
Affidavit is there, no?
Affidavit is there. So you're not
60 years.
eligible.
60.
So it's up to 21 years only, then what to do?
21 years, Lordship, this is irrational, Lordship. Because
Now you have to challenge this notification.
No, whether it's irrational or not, how can we decide that unless you challenge it?
Note 5 says the eligibility of dependent father, mother, brother up to age of 18.
There's no provision for pension. If you are 60 years.
What will be the rate of my loan which was taken by my
Maybe.
brother? Gratuity I am entitled of. Revaluation I am entitled.
And what will stand to page number 19, my lord. This service book, my lord. The date of birth is 1/2/1965.
Yes.
So as on date, my lord, yesterday after 58 years, he expired in the year 58 years, 3 months, 7 days. That part of the that he can claim all the gratuity, whether that another 1 and 1 is something, that full payment. There is another notification that can be claimed.
Which part? Gratuity.
Gratuity and other, but he has to show that he is the elder brother, that all.
Yes, yes.
That has to be, he need to be.
Sister, elder sister.
Sister.
Yes, I have.
The legally entitled, legal heir of the.
Yes, I have shown in an affidavit at page 46, Lordship.
Technically, there will be a next of kin certificate and all these things.
So you approach the respondent authority with appropriate application.
Yes,
Yes, sir.
So you'll withdraw this.
Yes.
That's paid for by Mr. Our learned counsel for the petitioner. The petitioner says this quota was withdrawn. We liberty to the petitioner to approach the respondent authorities concerned for payment of retirement dues as may be permissible in law. Mr. S. Bora, learned study counsel.
That's one of PTC.
PTC appear for respondent number 4.
Public.
Yes.
Regarding pay protection. Pay protection, my dear. Earlier, I was appointed as LP school teacher. And now, after a fresh appointment as assistant teacher in Katoha Tribal School, then Katoha Tribal School has been merged, my dear. with
Will
my-
issue notice?
Yes, my.
Heard Mr. S.B. Laskar, learned counsel for the petitioner, who submits that by filing this petition, the petitioner has paid for protection of his pay in terms of FR 22. Issue notice of motion returnable by COVID. Mr. U. Sharma, learned studying counsel. Elementary education. Accept notice on behalf of.
That's on the number 120.
No, 112. Not elementary, secondary.
And the extra copies may be fine.
You are for secondary, isn't it?
Yes.
Secondary education. Petitioner to serve requisite extra copies within 3 days.
Highly obliged, my dear.
This is also similar lordship, that is the submission of BSA after the last date of the same as and this.
Withdraw?
Dispose, maybe dispose.
The issue raised in the instant writ petition has already been settled by this court. Right, common order dated 1/8/2025. Wherein the lead case was WPC number 3929 of 2025. Open bracket, Nayan Sharma and others versus State of Assam and others. Hence, the petition stands dismissed in accordance with the said direction. Mr.
K. Alam.
K. Alam, learned counsel appears for the petitioner, while Mr. S.M.T. Chisti, learned standing counsel, secondary education, appears for the said department.
May it please your lordship. Lordship, the engaged counsel is on legs in court number 1, your lordship. Matter may be passed over for the time being, your lordship.
50% fine. Who's on legs?
Lordship, senior advocate Ken Chaudhary is on legs. He is engaged in this matter. In court 1.
Passed over. Yep. None appeared. For the petitioner on the matter, matter stands adjourned.
Fifty. 54.
Huh?
Lordship, item 54.
The matter was just called. I adjourned it.
It's senior is coming. Lordship. Just
Time being.
May I please your lordship? May I please your lordship?
Yes.
Lordship, this contempt application has been preferred against the judgment and order dated 19/10/2023, your lordship. Lordship will find at page number 12, lordship. Lordship, the relevant para, operative para, your lordship will find at page number 39. Lordship, what has happened, lordship? Three directions were there, lordship. Out of the 3 directions, lordship, 2 directions has already been complied, lordship. I was directed to be reinstated, lordship. I have been reinstated. Therefore, lordship, the current salary has also been paid recently, lordship. But lordship, so far as the arrear salary is concerned, lordship, that has not been paid till date, your lordship.
Where is the order? Operative code.
Lordship will find at page number 39, your lordship. If I may read, your lordship, it starts from page number 38, para 40, your lordship.
You're talking about paragraph 41.
Para 40, your lordship. Oh yes, para 41. I'm talking about para 40.
Arrear pay and
Back wages
back
and arrear
wages.
pay,
This
lordship.
is not given.
The lordship, I've been reinstated and been paid the current salary, but this is not been done till
Yes.
date.
Paying lordship. Some instruction is received, lordship. Can to hear for not timing, lordship. He will come, lordship. Some instruction is received, lordship. But he send me to hear also by.
Lordship, may taken up at 2, lordship, at 2 p.m.
At 2 p.m. there's another matter.
Oh,
Some instruction is received.
Okay, time being.
deeply obliged, lordship.
Yes.
The matter will be passed for the time.
Wait.
My senior is on the.
You do the case. This is not a new case also. It's a contempt matter. Oh no, it's a writ petition. Okay.
No, it is, we are for the in chargeship of the principal. So we were the senior most teacher. Our name was reflected in the serial number 1 of the senior list. But somehow, the respondent number, the private respondent.
Today we are concerned about notice. Today we are concerned about notice to respondent number 4. Correct. That's why this.
Yeah.
That is why it's listed for orders. So as per the Lavazema court's order, it's complete.
Completed, yes, ma'am.
Please write upon perusal of the Lavazema court's order dated 25/7/2025. Notice is accepted to be complete on respondent number 4. Your good name?
TL Chaudhary.
PL.
TL.
TL or PL?
TL. T.
Mr. TL Chaudhary, learned counsel appears for the petition. Well, Mr. U Sharma, learned standing counsel.
Order number 1.
Secondary education. Appears for respondent numbers 1, 2, and 3. This is the matter in the admission column after 2 weeks.
My lord, can a date be fixed?
They'll fix it on a date to be fixed by the registrar.
Complaint.
Lordship may kindly peruse the Lavazema court's order. Service regarding respondents are conflict. Lordship may kindly fix it for admission column.
Okay. Upon perusal of the Lavazema court's order dated 18/4/2025, notice is accepted to be complete upon respondent number 4. Please the matter for India under the admission column after 2 weeks on a date to be fixed by the registrar.
Lordship, I beg to submit one more thing, Your Lordship. There's another matter, WBC number 1769 of 2025, which is identical to these matters. So, Lordship, that may be also fixed for admission column because Lordship, the learned government council accepted notice for all the respondents.
It's similar with this case.
Identical matter.
Okay, along with WPC number
1769 of 2025.
1769
Yes.
of 2025. Okay.
Yes. My lordship, my senior AR counsel, my AR Bhuya is on leave, so I kindly request you to pass over the matter for timely.
Directed to receive instruction. Yes, to receive instruction.
And on the IA?
Yes.
What is the IA for?
I was start focus notice for not assuming his was absent.
Not to
Very
proceed
well.
in a parallel manner. What is the matter? What instructions are you required to take?
Focus.
You want some more time?
Yes.
How much time?
1.
A week's time, okay. As paid for by Mr. G. Pegu, learned standing counsel. School Education Department. Elementary, is it?
Yes.
Elementary Education Department. Further 1 week time is granted to obtain instructions in the matter. List again after a week on a day to be fixed by the registry. Miss A. Pukan, learned counsel, appears for respondent number 6.
Right.
42.
Yeah.
Yes.
In this case, I'm playing for a similar order, my lord. It is the given in the page number 74, my lord. With regard to beard increment, my lord, upon once more.
Yes, what is this similar order?
Yes, sir. With regard to grant of beard increment, my lord.
Would you bother to explain what is that?
Lord, the petitioners have acquired the BEd degree, my lord, and they are serving as the graduate teachers in the high school, secondary schools. And this honorable court, in respect of the similar case, pass this order, similarly teacher candidates pass this order, my lord. And following that, my lord, the compliance order has
No, you get B.Ed, then what do you get? Additional increment.
additional.
As per what? That what
As per-
provision?
As per, my lord, the circulars are there.
Where is that? Show me.
Yes. The lordship will get it, the circular. Page 72, my lord. This is issued in pursuance of the direction of this noble court.
Mr. Prokasta,
Yes,
would you don't want to explain what is your case about?
my lord, the
Simply
petitioner,
saying, I want similar order, that's all.
the petitioners have, my lord, passed their BEd degree, my lord. They
Ah.
were appointed prior to 3/7/2012 on regular basis. And they have passed their BEd qualification from UGC recognized university and the NCT approved college.
How many petitions are there?
And my lord, petitioners, nine petitioners. And,
Mr. Sharma, what do you say?
this honorable
In
court,
this regard, I have to go through the judgment and the case regarding the petitioner. And moreover, here my lord, finance needed to be party my lord.
no,
So my lord, sometime will be granted so that I can go through that case and if required instruction will be obtained from the department my lord.
let it come on Monday, my lord.
List again on Monday.
At least 10 days my lord, will be granted. 10
Monday is
days
not
may be
sufficient.
granted
Why?
so that
It's from Nalbari only, my
I
lord.
obtain the instruction from the department.
It will come from Nalbari, my lord.
10th of September. List again on 10th of September. In the meantime, Mr. U. Sharma, learned standing counsel, Secondary Education Department shall obtain instructions and also examine as to whether the case of the petition is covered by the order dated 16/9/2021 passed in WPC number 4005/2021, bracket annexure 6A.
Obliged.
After some time, your lordship, start before division better. For division.
May it please, my lord, matter pertains to the fact that my lord, for one of my subjects, I'm a LL.B student, my lord, pursuing my LL.B degree from Tezpur Law. My lord, in one of my subjects, my lord, my marks of my practical examination had not been counted, and because of that, I have not been able to qualify for my LL.B degree.
Which is?
My lord would kindly have, my lord, till that exam, that is 6.1 paper, my lord, labor and industrial law. My lord would kindly have page 22, my lord.
Yes, what happened to that paper?
My lord, in that paper, my lord, initially I had obtained 31 marks out of 80 and practical 15 marks, because of which I didn't qualify. Thereafter, my lord, I had sought for evaluation of the said examination, my lord, that theory paper. After the re-evaluation, I got 36 marks. However, my lord, and 36 plus 15 means, my lord, 51 marks. As per that, I should have qualified. But my lord, I was verbally instructed by the controller of examination, Guwahati University, that I have to again appear for that particular paper in the next academic session. Again, I had appeared, my lord. Then I got 45 marks in the theory paper, but to my utter dismay, my practical mark, that 15 marks which I had got, in that column, it was shown as absent. So ultimately, I only got 45. The qualifying is 50, and I again failed. That is the crux of my case. My lord may kindly have page 22 for a moment. 22 is the relevant page.
Yes.
22, my lord, the first paper, my lord, 6.1, labor and industrial law 2. Total marks 80. This is the theory paper, total 80. Pass marks, I got 36, my lord, in this paper. Pass marks is 36. Marks obtained 31, fail. There is a F also against it. Total marks obtained 46 F, my lord.
How much are you supposed to get?
I am supposed to get 36, my lord, for qualification, but I got 31 F. 31, that is failed.
And what is this 15 below?
15 is the internal mark.
Okay.
For the internal, that is out of 20. Thereafter, my lord, as I was of the belief that I had performed well, fared well in the said examination, I had applied for re-evaluation. My paper was at page 26, my lord would have the marks for re-evaluation. My lord would find it at the bottom portion.
26.
26, bottom portion, my lord. Labor and Industrial Law 2. LL.B 6.1.
Yes.
Here, my lord, if my lord kindly peruses that column, my lord, of Labor and Industrial Law 2, it will show, my lord, 80 plus 20, 36 plus 9. And this is my marks, my lord. The third column, 36 plus 15, which means 51. In the re-evaluation paper, I got 36 marks, which is the passing mark.
This is for which academic years?
This is, my lord, that academic year only, the paper was re-evaluated. Same year, re-evaluated.
Same year must be having a year also. What is the year?
My lord, that paper.
Oh. What is that academic year? That's all.
My lord, the academic year is
You
22.
simply say same year. What is same year?
22.
2022.
Yes.
So on reevaluation, you got 36 marks,
Yes,
plus 15 is internal.
yes.
Despite that, you have been asked to reappear again.
Reappear again in the next academic session.
And in the next academic session, when you reappear,
Yes.
now what will happen to the internal marks?
That was not added, my. It
That
had-
will have to be carried forward,
Yes, my.
or they have to assess again.
My lord, to that, my lord, they have not stated anything. So we were also under the impression that the earlier marks would carry, since they have not stated that whether we have to appear fresh for this year
So-
examination.
Okay, that is your belief and what has not happened. So what would be the position?
My lord, responding authorities might kindly clarify.
So show me, where is that?
Yes, my. My lord would kindly have page 30, my lord. 30.
30.
30.
Yes.
That is the form fill up, my lord. I'm just taking through the form fill up, my lord. And page 34 is the relevant page, my lord. 34. 34. It's 19/9/2024.
No,
The mark
30.
sheet.
What is 30 otherwise?
My lord, 30 was the form fill up page, my lord. That I had filled up the form and appeared for the examination, my lord.
Okay.
At page 34, my lord would kindly have. My lord, may I read?
Yes.
Labor and Industrial Law 2, total marks 80, pass marks 36, marks obtained 45, and in the beneath, my lord would see that absent, my lord, in the internal column, internal examination column. Because of that, I failed, and I have not obtained my LL.B. degree till date.
What is your prayer here now?
Prayer, my lord, I have preferred two representations, my lord, before the authority, my lord, to reevaluate my paper, my lord, that paper carrying my internal examination. Since they have not stated anything about the fact that whether my internal examinations are going to be carried or not carried, or whether I have to appear fresh in the next year, my lord, when I had appeared for the exams in the next academic session. Therefore, my lord, if the marks are going to get carried, then it may be carried. And if not, I may be allowed to appear for the practical examination afresh. Because I just need 5 marks to qualify. I have 45 marks. I just need another 5 marks.
Where's your representation?
My lord would kindly have page 35, my lord. This is to the Controller of Examination, Guwahati University.
Dated?
Dated, my lord, 23/9/24, my lord.
Before that?
Before that also, my lord,
No, this is after that.
Yes, ma'am. There's one more, my lord.
Yes, June, 27 June.
Yes, ma'am. This one. It's been a while. It was আগত থাকিব।
Page 37.
Yes.
There's no response to this?
No, my lord. It has not been considered. In fact, my lord would have. Itu dia na, Tesco University itu the principal dia tu. Itu na. In fact, my lord would have page 41 also. I had preferred through the principal Tesco Law College, my the said representation was routed. So it is in the knowledge of my parent college as well.
41.
41.
What is this? It's hardly legible.
My lord, this was before the page. My lord, that application, my lord, 26/6/25 application representation that was routed through the Tesco Law College.
How do we know? It's not legible.
My lord, page 40, it's the legible page. 40.
Mr. Fukan?
Lord, I take your law straight to page 28 and 20.
Page 28.
28 and 29. 28 is the type of paper.
Yes.
To appear before unfair means committee. 28, Miller.
Yes.
It is from the Controller of Examination, Guwahati University, to the care of Principal Tesco Law College. You are hereby asked to attend the office chamber of the Controller of Examination, Guwahati University.
on 18/5/23 to unfair means committee. Therefore, you are hereby informed that you would be attend the office chamber of the undersigned at appropriate time. So, my lord, after appearance before that unfair committee, what happened without your
We have not been informed.
What is this kind of committee? Unfair means committee.
My lord, possibly, my lord,
What do they
some
do?
unfair means, my lord, has been adopted by the petition. So that is why
Acha, that way.
he was asked to appear before the unfair means committee. And thereafter, Lord, the another aspect, whether that internal examination marks of earlier year could be carried over to the next year, is also, my lord, not clear. And the presence of that to law for it is required, I think.
I've made them party member.
Will issue notice that. Hard Mr.
PR so.
P.R. Sharma, learned counsel for the petitioner. Who submits that. The petitioner appeared in the LL.B. final semester examination 2022 from Tezpur Law College, wherein he was found to have scored only 31 marks. Whereas the minimum marks to pass the exam was 36 marks. Most of the petitioner was also shown to have scored 15 marks towards internal assessment. To stop not being satisfied, the petitioner sought for re-evaluation. Where he was found to have scored 36 marks. Stop nevertheless, as advised, the petitioner again sat for the re-examination in the year 2022, bracket June. And he was able to score 45 marks. Acha, I forgot to tell you the subject. Okay, the beginning part. 31 marks. After that, you just add in labor and industrial law, dash Roman 2. Before labor, again, you add one more thing, 6.1. Name of the subject. 6.1, labor and industrial law, Roman 2. Although the petitioner secured 45 marks in the examination, he was shown to be absent for the internal assessment, and accordingly he was again marked as fail. So the petitioner submitted the presentation before the controller of examination through proper channel on 23/9/2024 and thereafter on 26/6/2025. But as no response has been made, petition is before this court. Next paragraph, Mr. B.J. Pugan, learned standing counsel, Guwahati University.
For respondent number 45 and go ahead.
What is that unfair means thing?
Page 28-20. And except for.
Submits that the petitioner was asked to appear before the unfair means committee on 18/5/2023. In terms of the letter issued by the Controller of Examination, Guwahati University, on 11/5/2023. So therefore, you will have to obtain instructions in this regard. And also, as regards the admissibility of carrying forward the internal marks in a subsequent examination. Next para, in view of above, issue notice of motion returnable by 4 weeks. Mr. P.J. Puvan, learned standing counsel, Guwahati University, accept notice on behalf of respondent numbers 4, 5, and 6. While Mr. S. Buyana, learned standing counsel, higher education, accepts notice on behalf of respondent number 1 and 2. Petitioner to take steps for service of notice upon the remaining respondents by registered courts to their detail within 3 days. Petitioner shall also furnish requisite extra copies of the writ petition to the learned counsels appearing today within 2 days. This taken after 3 weeks on a date to be fixed by the registry. Learned counsels for the respondents to obtain instructions by them.
Please, my lord, may I have one last prayer? My lord, if the pendency of the writ petition may not be a bar for the respondent authority, particularly the controller of examination of Guwahati University, to reevaluate my paper, my lord. And if in case they find any solution to this, my lord, my paper may be cleared. Otherwise, I'm kept in a limbo, my lord, not able to obtain my degree. That is why I've made it.
See,
That re-evaluation is complete.
re-evaluation has already taken place. Now question is whether your internal assessment marks can be carried forward or not. That much only.
If during the pendency, if they find that my case is positive, then maybe that observe it. If it is
Pendency of the writ petition will not be a bar for the respondents to mitigate the grievance of the petitioner.
deeply this book cycle replaced by the which a reconstruction is required. So, provided data to the college to reconstruct the sample. It was in that.
Yes. This reconstructions will be required for payment of back wages.
Yes, the college will have to forward it to the department.
Because
College need reason.
Mr. Bora, your colleague informed me that all the directions have been complied with, except for the back wages.
Only for the back wages.
Hmm.
Now,
Arrear pay and back wages.
now they say that the service book has been not there. However, without the service book, the area statement cannot be prepared. Therefore, Lordship, it was sent to the director, the area statement and the service book from the college. And they have done it. So it is with the director only. Now, because there was no acknowledgement, they are taking advantage of it now. But it is there is reconstruction of the service book is not required because it is already in custody of the college. If they require it, they can again call it from the college.
That's not the case. It's now not with the department, with the college only. If required, if it is with them, let them participate. But it's better, but what it was submitted, they say it was submitted. Somehow it is not there. I said, we did our.
You're for the college.
I'm
You,
for the college.
you're for the
Because
college.
it is letter, it changed my lord.
So service book is with you or with them? With whom?
It was sent to them, my lord, as per the statement. It didn't state, my lord. Though as per your letter, this book of today's are therefore submitted to this, my lord. However, you have not submitted any acknowledgement. So because of acknowledgement, now they take it this time. They're putting us on fast, my lord. So anyway, my lord, I will definitely.
The college can again furnish it.
If it is there, that what is. If
And-
possible, it will be taken off.
Lordship would kindly have a look. On November 2024, the area statement has been submitted to the director. Now the director, the contempt was pending, but they was reluctant to open the file also. Now after 9 months, they say that it is not there. Lordship would kindly see the order dated 11/12/2024. Lordship records this, that area statement has been
No.
prepared and sent to the department.
Just a minute. See, you have given me this letter.
Yes.
You have given me this letter. You have a copy?
Yes.
You have a copy.
Yes.
Just look at the reference.
Yes.
7/4/2009, what is this? And 27/11/2024, what is this?
These are the areas that calculation part made by the college, but for their verification also that the service book is required, which is in their custody. It's not without. So lordship, since my colleague is saying that it's with the college on, they can furnish it.
He's also saying that they don't have it.
Maybe, ma'am, I don't know. So I have to take instruction on that. Yes, let them, as far this letter even it was sent to them, ma'am. So they are saying the only acknowledgement could not be produced from us. That's why they are saying. So you have to reconstruct. That was their letter. That was their version. Not, we are not saying that we have a receipt. So. Once we get it, get the service book. The rest will be. The 9 months they are coming up with this. Anyway, my lord. I may take in, I'll take it.
In the record of the court, Lordship, there is everything, even the area statement at page 2C.
Whatever it may be, you do it, you do the needful.
Yes.
And what is the requirement of the service? Because area statement is already prepared, therefore, service book, whether there is a requirement or not, that is also another question.
Please write down. According to the petitioner, the judgment and order of the court dated 19/10/2023, passed in WPC number 2555/2020, has been complied with, except for the payment of arrear pay and back wages to the petitioner. In terms of paragraph number 41 of the said judgment and order. Next para, Mr. A.R. Tahibildar, learned counsel for the respondent. Number 1, submits that the error pay and back wages is still pending only for the want of the service book of the petitioner, which has been requisitioned from the college principal, LBC College, Maligaon. Sorry, LCB College, Maligaon. To stop, the said authority has also been informed that if the service book is not available, the same should be reconstructed as per letter dated 27/8/2025. Mr. S. Mukhtar, learned counsel, appears for the respondent number 2 and submits that the respondent number 2 will be furnishing the service book to the respondent number 1 without delay.
In fact, whether it is available or not.
Stop. He also submits that if the same is not available, the same will be reconstructed as may be required. Considering the above submission, let this matter be listed again 2 weeks. After 2 weeks, on a date to be fixed by the registrar.
May be pleased to give a date.
They'll fix a date on a fixed date.
Right.
Next.
My lord, the petitioner before lordships, she is working as a assistant professor in AIMS Guwahati in the Department of Pediatrics. Now, my lord, she has been, her services as a provisional has been terminated. We are agreed by that. That is where before your lordships.
Terminated.
Now, yes. Now, my lord, today it will be effective from today, my lord. Now, what had happened? She was subjected to sexual harassment by respondent number 6, her headmate. So the matter was referred to internal complaint committee. Internal complaint committee deliberated upon it and found the allegations to be correct. And accordingly, internal complaint committee recommended for taking necessary action as per that act, central act. Now, my lord, what the respondent number 5, who is the executive director of the institute, my lord, he closed the matter. Then we approached this honorable court. Now, please have a look at that observation, my lord. That observation lordships will get at page number 107. The judgment starts at page 99, but I'll have your lordships, sorry, 107.
Great.
Para 20. Be that as it may,
Yes.
be that as it may, this court is of the opinion that while the impugned communication dated 4th of April 24 is held to be unsustainable in the eyes of law, as the same has been issued by an authority without jurisdiction, matter is to be remanded to the appropriate authority to take a call. I'll just give a little background, my lord. The respondent number 5 is the executive director of the institute. He took a call on the recommendation of the ICC. We say he is not the authority, this is the governing body who is competent. It was in that context, this finding was recorded, my lord. However, in view of the development also taking into consideration the observations made by this court in orders dated 3/5/24, 11/12/24 and 14/2/25, it is provided that if governing body assumes the role of disciplinary authority, the respondent number 5 would not be a part of the same and his place be taken by any other officer of equivalent rank. They say the direction has been made by invoking the doctrine of necessity, etc., etc. So what this honorable court said, my lord, that now as an executive director, respondent number 5 could not have taken a call on the recommendation of the ICC. It is the governing body who will take, but since by virtue of his office, he is an ex officio member of the governing body, he will not take part in the deliberation. Now matter was remanded to the governing body. Now, my lord, I'll draw your lordship's attention to one order which is very important. Please come to page 98, my lord. My lord, I was being harassed by issuing office memorandums. 3 orders were passed by these 3 orders are referred to in the para 22. Please come to page 98, para 8. Such action and conduct on the part of the executive director, All India Institute of Medical Sciences, Guwahati, in the backdrop of the litigation and the order passed by this court, in the considered opinion of this court is suggestive of malicious action. Therefore, subject to further deliberation and respondents and responses that may be made by the respondents in the IA, as an interim measure, it is provided that warning letter dated 3/2/25 shall remain suspended till the next date of fixed. This honorable board went to the extent of recording observations like this against respondent number 5. Now, my lord, the moot question is whether this order, which is at page number 134, my lord, is sustainable. Page 134 is the impugned order.
134.
Yes, my lord. That is the notice of termination. In fact, they have given us 3 months pay in lieu of notice. That is permissible. We are not on that. I'm on otherwise. In pursuance of the terms and conditions mentioned in the appointment letter referred to above, I hereby, on behalf of the competent authority, give notice to Dr. Nisha Tuteza, presently serving on provision period, that she has been found unsuitable for confirmation while being on provision, and her services shall stand terminated with immediate effect from 1/9/25. It is also informed that the institute will pay 3 months pay in lieu of notice period by which the notice falls short. My lord, my first submission is the Dr. Ashok Puranik, who is respondent number 5, he is not competent to issue this letter because the authority is governing body. And secondly, this honorable court has already said he will not be associated with any proceedings where I figure. That observation of a coordinate bench I have already placed. Now, if your lordship would kindly come to the regulation of the institute, my lord, that is at page number 1, page 61, at page 78. Page 78.
Yes.
If your lordship kindly see, this is schedule 2. On left-hand side, first column is serial number, then the description of post. Now, group A post director, he is not director, other post. Who is the appointing authority? Governing body. So, my lord, competent authority is the governing body, number 1. Number 2, this honorable court has already said that respondent number 5, who is the executive director, because of his partisan role being played all throughout, he will not be associated with any decision-making process, yet he had taken part.
Or on behalf of the governing body.
Yes. Now, my lord, will kindly see their attitude, my lord, because the interim orders were holding the field. If your lordship should kindly come to page 85 for a moment. One last order. My lord, lordship may kindly take note, I was appointed on provision on 10/6/22. 10/6/22. Now, if your lordship kindly comes to page 83, my lord. After 1 year and 4 months of service, this experience certificate was issued by the institute. This is to certify that Dr. Nisha Tuteza has been working Department of Pediatrics, Guwahati, with effect from 2/7/22 to till date with so-and-so. The post held by her is a teaching post. During this tenure, her work and conduct were very good and integrity was beyond doubt. Now, my lord, in spite of this, an extension was given at page number 84. All my lord nullify the exercise of power by respondent number 5 and 6. Kindly see, my lord, the provision period of Nisha, Toteza, etc. is hereby extended for 1 year with effect from 2nd of July 24. Then, my lord, will kindly come to page 85. Now, kindly see the language. As if, my lord, they would have dismissed me, but for the court proceedings, my lord, after the court's order. The court's order of the coordinate bench was of, my lord, 5th of June 25, and this order is passed on 1st of July. It is hereby notified that in accordance with the
Page number?
page 85, madam. I'm sorry.
Yes, 85, yeah.
It is hereby notified that in accordance with the decision taken by the governing body during their extraordinary meeting held on 24/6/25, the provision period of Dr. Nisha Toteza, Assistant Professor, it is hereby extended for additional period of 6 months with effect from 2/7/25 or till completion of ongoing deliberation by the governing body on the matter of her complaint on sexual harassment, whichever is earlier. As if, my lord, they are waiting for their governing body's decisions to be taken pursuant to the order of this honorable court. Now, my lord, the governing body, they has dropped the proceedings at page number 113. At 113, this is for information of all, has your lordship got it? Page 113. Pursuant to the direction of the coordinate bench, this is the decision which governing body had taken. This is for information of all concerned that the WPC filed by Nisha Toteza was disposed of by Honorable Guwahati High Court by its order dated 5th of June 25 with direction that governing body of AIMS Guwahati should take decision on the complaint of sexual harassment made by Dr. Nisha Toteza. After examining the contents of the complaint and the ICC report vis-a-vis available rules, guidelines, documentary evidences, and deliberations, governing body has taken a final decision as follows. The complaint of sexual harassment against Jayasankar Kaushik made by Nisha Toteza is not substantiated by available record evidence and matter stands closed forthwith. Now kindly see, my lord, copy to so-and-so, 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 including director. Now, my lord, lordship knows, as per the decision in Medha Kotwal, the Honorable Supreme Court had said, my lord, that the ICC report is to be treated as an inquiry report. And the proceedings should start from that stage. That means ICC report would be given to the delinquent. Delinquent will be asked to submit reply. Then disciplinary authority, that is governing body, will take a call. Have we ever come across a single instance in service jurisprudence where after inquiry report is submitted, disciplinary authority takes a call on the inquiry report? Well, that is a stage. If upon submission of the show cause reply, the authority is satisfied that there is no case for proceeding departmentally, then departmental proceeding can be closed. But once inquiry officer is appointed, when inquiry report is there, then the disciplinary authority's duty is to act on it. And the Supreme Court in Medha Kotwal's case has said, my lord, and based on that, the Central Civil Service Rule has also been amended. Now, therefore, now here is a case, my lord. Can you see the malice in law? How, my lord, I have been victim. I am a subject of sexual harassment. Instead of, my lord, ameliorating my condition, what the authority has done, they have exonerated respondent number 6, who is the head of the department, and against whom there is a findings by the ICC. Secondly, my lord, initially the call was taken by the respondent number 5, the director, whose action was found to be wrong by this honorable court. The matter was remanded to the governing body. The governing body's role was to, my lord, take the proceeding to its logical end against respondent number 6. Instead, what they did, my lord, they closed the ICC report itself. And now against me, this order has been passed. As if, my lord, by bringing it to the notice of the authority that I am a victim of sexual harassment, it's a folly, my lord. Well, it's absolute arbitrary action, my lord. Now, therefore, to articulate my points, my lord, number one, the competent authority, jurisdictional authority has not passed the order. Therefore, it is an order without jurisdiction. With mystery and my lord Malafites. Thirdly, the inquiry against respondent number 6 must be taken to its logical end. Fourth, but not the least, my lord, how can such a situation you can even visualize in a service jurisprudence, my lord? Therefore, my humble submission is, my lord, lordship will state his order because it will take effect only from tomorrow.
Directed to provoke a circular.
Yeah, and kindly see, my lord, our High Court, the coordinate bench at page number 108 has specifically directed that the rules and regulations should be followed.
This stage.
Please come to page 107, para 22. The competent authority, para 20, is accordingly directed to complete the proceedings expeditiously and with an outer limit of 2 months from today. It is further provided that while competent authority would consider the matter, the stakeholder, namely the petitioner and respondent number 6, be given opportunity to represent themselves. At this stage, Mr. Gupta, learned Central Government Council, has submitted that OM dated 4/11/22 is presently followed. It is needless to state that all actions be taken strictly in accordance with law, including the OM placed on record. Now, this is also important, my lord. It is also provided that till a final decision is taken, interim order passed by this honorable court also shall remain operative. Now, if your lordships will kindly come to that circular, which is at page number 141, my lord, there is a requirement of giving an opportunity of improvement, my lord. Page 141, the same very circular which the counsel for the respondent was referring in the earlier case. Please come to para 24 on top, my lord.
Yes.
Confirmation is dealing from availability of permanent vacancy in the grade. In other words, an officer who has successfully completed the probation as prescribed under the rules may be considered for confirmation. Consequent upon the above decision of delinking confirmation from availability of permanent post, it emerges that confirmation will be done only once in the service of an officer, which will be the entry grade post, etc., etc. Para 25. If during the period of probation or any extension thereof, as the case may be, government is of the opinion that officer is not fit for permanent appointment, the government may either discharge or revert the officer to the post held by him prior to his officer in the service. That he should be given out there. So, no, it is. Clause 7 asil niki?
26, I think.
1 second, my lord. Yes. I'm sorry, my lord.
26 last
Page,
part.
sorry, my lord. I'm sorry. Page 137. Para clause 7. Page 137.
Okay.
A provisioner who is not making satisfactory progress should be informed of his shortcomings well before expiry of the original provisionary period, so that he can make special effort at self-improvement. This can be done by giving a written warning to the effect that his general performance has not been such as to justify his confirmation, and that unless he shows substantial improvement within a specific period, the question of discharging him would have to be considered. Now, my lord, I have already placed page 83. Up to, my lord, after 1 year and 4 months, my conduct was found to be satisfactory. I was found to be a person of impeccable integrity. Now, after I submitted this complaint of sexual harassment, my lord, everything, the grapes have become sour. Now, therefore, my lord, the point to be seen is
though the order of termination is, my lord, it is basically sought to be portrayed as if it is a termination simpliciter. But in effect, my lord, I filed a complaint before the PMO. That is the reason they have done all these things. Now, I'll just place one paragraph of the Supreme Court decision, my lord. 2015 SCC 151. Sorry. Well, I'll hand over the copy, my lord. I'll just read that paragraph, then.
Is there
I'll hand
any,
over.
Mr. Chaudhary?
Yes.
Is there any other case pending on this?
No.
The earlier round was disposed of. This is the second round.
Nothing is.
Okay.
My lord, my humble submission is best. My lord, assuming these allegations are not there, if it is certainly founded on an allegation. The allegation is, I filed a complaint before the PM regarding some misconduct of respondent number 5. Against respondent number 6, my specific allegation is sexual harassment. And sexual harassment, my lord, the report is there. Against respondent number 5, my allegation is there are some financial irregularities which I submitted to the PM. That is why, my lord, this everything has been done. Therefore, my lord, the Supreme Court in the ultimate analysis says, if in the process of finding my suitability, if they record a finding, then it will not be misconduct. But if they take note of a misconduct, then it will be, a foundation, in which case Article 311 is affected. So, my lord, looking at the attending facts and circumstances, there is a live connection between my complaint to the PMO and their action of discharging me. Therefore, it's a case of, my lord, where some allegations are the basis for this order. Though the order is portrayed to be an innocuous one, it is actually not. Therefore, my humble submission is, my lord, Lordship will protect me during the pendency of this case.
But what is wrong with this page 113? You said?
113, yes. This is wrong because, my lord, they cannot do this. This is wrong for the simple reason, my lord. Once an inquiry report is submitted, where there is a finding of guilt is recorded against respondent number 6, their duty is to punish respondent number 6, not to close this report.
That report is what? By the
ICC.
I see.
Internal Complaint Committee of the Institute.
Is it available here?
That report we have not annexed. It is there, my lord. There's no dispute. Now, in the earlier judgment, this is recorded, my lord. If your lordship should kindly come to.
No, see, they have examined, they say that after examination of the contents of the complaints and the ICC report.
Yes.
Vis-a-vis the available rules, guidelines, documentary evidence, so and so. Governing body has taken the final decision as follows.
No, where is the power of the governing body? My lord, can we visualize a situation in a DP case? Inquiry report submits his report. Then, my lord, it is given to the disciplinary authority. Then what disciplinary authority will do? Disciplinary authority will forward it to the delinquent. That is situation number 1.
Submit a representation of.
Yes. Situation number 2, supposing in the inquiry report there are favorable findings in favor of the delinquent, in which case the disciplinary authority can differ, saying that no, on the facts available, we are inclined to record a finding of guilt. So therefore, they will call upon the delinquent to, my lord, make their submission. Thereafter, disciplinary authority will pass an order on punishment. My lord, inquiry is over. Respondent number 6 is found guilty. Now, where is the scope for the disciplinary authority to interject at that stage? It is unheard of. Subject to correction, my lord. I have not come across any case. And, my lord, page number 101 of the judgment, my lord, where these facts are noted, my lord. Para 3, my lord, at page 101. The petitioner, who is working as an assistant professor in the Department of Pediatrics at All India Institute of Medical Sciences, had filed a written complaint on 17/8/23 of sexual harassment at workplace against respondent number 6. It is the case of the petitioner that even after such complaint, harassment had continued and on the contrary, respondent number 5 had issued a warning letter to the petitioner. Be that as it may, matter was inquired into by internal complaint committee, wherein the respondent number 6 was indicted. However, by impugned communication issued by administrative officer with the approval of the competent authority, findings have not been accepted. It is legality and validity of such action which is subject matter. My lord, where is the question of disciplinary authority taking a call straight away on the basis of the inquiry report? They are bound to accept it. It is their committee, my lord. That's why Supreme Court says in Medha Katwal's case that this report should be treated as an inquiry report and the action will start therefrom. And the procedure is laid down in the OM itself, my lord.
So what you're saying is that the authority is bound to accept the inquiry report.
Yes.
Can it not differ?
No, no,
Why not?
no, my lord. That stage is over. That stage is over, my lord, with all respect.
No, see, even in the normal inquiry,
Yes.
supposing inquiry officer is appointed, he conducts the inquiry, submits the report. The disciplinary authority may or may not accept the inquiry report.
No, my lord. I think
It may say that there's no the finding may be in favor of the delinquent. Still, the disciplinary authority may still differ.
No.
Say no.
my lord, my humble understanding subject to what your lordships may say, that stage is, my lord, when the so-called notice is issued, then the delinquent submits his reply. Then before appointing inquiry officer, that satisfaction has to be recorded. Once inquiry officer is appointed, that is not available. At least rule 14 of the CCS rule does not say so. Our rule 9 of the Assam Civil Services rule does not say so. That stage is to be exercised at this stage prior to appointment of the inquiry officer. Once inquiry officer is appointed, it has to be taken to its logical end. At least there is no power, my lord. First, we can have a look at rule 9 of the Assam rules, same principle, or rule 15 of the CCA rule. Now, if your lordships would kindly come to 122, my lord, where the central government itself has laid down the procedure at page 122.
Yeah.
Inquiry under CCA rule, second stage. Kindly see, my lord.
Yes.
In the light of the proviso to rule 14.2 mentioned above, the complaint committee, that is ICC, would normally be involved at 2 stages. First stage is investigation, already discussed in the preceding paragraph. Second stage is when they act as the inquiry authority. It is necessary that 2 rules are clearly understood and inquiry is conducted as far as practicable as per rule 14 of the CCA rule. Failure to observe the procedure may result in inquiry getting vitiated. As the complaint committee also acts as the inquiry authority in terms of rule 14 mentioned above, care has to be taken that investigation stage, that impartiality is maintained. Any failure on this count may invite allegations of bias when conducting the inquiry and may result in inquiry being vitiated. As per instruction, when allegations of bias are received against an inquiry authority, such inquiry required to stay the inquiry till the proceeding takes a call, etc. But if the allegations are biased, so and so. In view of the complaint committee, when investigating the allegations, should make a recommendation on whether there is a prima facie substance in allegation which calls for conducting formal inquiry. They should also avoid making any judicial recommendation expressing views which may be constitute petition. All of this stage that they will not proceed with the inquiry has to, my lord, precede the appointment of the inquiry officer, not follow. So, my lord, Medha Katwal's case, the Supreme Court has clearly laid down that, my lord, that this inquiry report is to be treated as an inquiry report of the inquiry officer. And the one I read is the one to which my learned friend was referring, my lord. So, a lot of, my lord, infirmities are noticeable in this case. and there is no dispute that I am a subject of sexual harassment, that there is a report in my favor. And there is a report against respondent number 6. I being the complainant, my lord, I am being terminated, and the, my lord, aggressor, my lord, the person who is guilty of sexual harassment, against whom, my lord, relief has been given. Kindly see the circumstance.
This has happened earlier also, isn't it?
Yes.
That communication dated 4/4/24. Is it similar to this one? Of page 113?
No, 4/4/24 was by the executive director.
Yes.
We say that governing body is the appointing, is the disciplinary authority. Therefore, the executive director, respondent number 5, could not have done. Our argument was accepted, my lord.
No, no. If you come to page 101,
Yes.
the earlier
Yes.
order, paragraph 4.
Be that as it may, inquiry by individuals when it was indicted. However, yes, this was challenged in this particular writ petition.
4/4/24 issued by the administrative officer.
Yes.
Which with the approval of the competent authority.
Yes, yes,
Findings have not been accepted.
yes.
So same thing has happened again now.
Again now.
At page
Yeah, that way, yes.
113.
4/4 was by an administrative officer, now it is by respondent number 5. Whereas our disciplinary authority is the governing body. And more so, my lord, there was a specific direction that respondent number 5 will not be associated with this inquiry because of the bias which we alleged. And my lord, their advocate also takes part in their proceeding.
Disciplinary proceeding.
111.
Page 111.
Same thing has happened, my lord. Earlier it was by the administrative officer. Now it is by the, earlier I was otherwise terminated. This time, my lord, is a discharge order. In disguise, it is a termination order. 137.
Respondent number.
No, but he himself issued the order. Okay, he cannot.
How it is clear in the DB meeting?
His lawyer.
His lawyer, the which order?
What about this observation again? Page
Law.
107,
Yes,
paragraph 20.
yes,
If the respondent number 5 should, no,
yes.
if the governing body assumes the role of a disciplinary authority, respondent number 5 should not be made part of the same.
If he's not part of the same, how can he issue the impugn order, Miller?
No, order is issued by one Dr. Babul.
No, no. Yes. Number 137, sorry, 140.
Oh, sorry, that
Yes, yes.
134.
Impugn notice at 134.
Okay, 134.
130 is by him, Miller. Dr. Ashok Pranik is respondent number 5. It appears, my lord, he was a part of the governing body. Despite the clear direction by this honorable court that he will not be a part.
But that report is not before us, isn't it?
Yes, that is not.
That report is against the respondent number
6.
6.
Well, there is no dispute on that report because in the first page of the judgment, paragraph 3 and 4 of the earlier order, Learned Singh 5/6/25 order, Learned Single just clearly notes that, Mida.
So you were saying that once that report is available, which is against the delinquent,
Yes,
then notice should go to him.
yes. Instead of closing it, this notice should have gone to him.
But will not the liberty of the disciplinary authority be there? Whether to act or not to act upon that?
Is 122 Malak is there. Is 122.
No, no, my lord. No, my lord.
122
Huh.
by the IGC. Second stage inquiry is has to be done by the governing body. The decision ought to have been taken by the governing body, which was wrongly taken because earlier set aside matter was remanded back. So there are two aspects involved. One is related to the allegations of sexual harassment, which report was not accepted by the executive director earlier, who has no authority to accept. That was interfered with by the honorable.
No, what are you saying? Not accepted? It was accepted.
So 4/4 order, my lord. So 4/4
Okay, it was not accepted.
Yes, and that matter was remanded, my lord, that appropriate authority will take fresh decision. So the governing body has now, my lord, taken the decision that the allegations of sexual harassment.
No, governing body has taken decision again on that
ICC
report.
By
Earlier also it was on ICC report.
Yes, by holding that.
There's no separate inquiry, isn't it? There's only one inquiry.
Yes, the governing body has afresh examined the ICC report and came to a finding that no, it is not a fit case to proceed. Now, whether that power is there or not, my lord, will see page 122. The office memorandum which holds the field.
122, which part?
122, my lord, last decision to issue charge sheet and conduct inquiry. The heading, my lord.
Yes.
It says on receipt of the investigation report, the disciplinary authority should examine the report with a view to see as to whether a formal charge sheet needs to be issued to the charge officer. Now that decision has now come in negative, that no, they thought it not a fit case to proceed because prima facie there was no allegation.
So this talks about investigation report.
That is the ICC report.
How does it differ from an inquiry report?
That investigation report is the ICC report now. My lord will see. Dual role. Dual role, page 122. In the light of the provision to rule 14(2) mentioned above, the complaints committee would normally be involved at two stages. The first stage is investigation already discussed in the preceding paragraph. The second stage is when they act as inquiring authority. It is necessary that the two roles are clearly understood. An inquiry is conducted as per as practical as per Rule 14 of CCS Rule 1965. Failure to observe the procedure may result in getting the inquiry initiated. As the complaint committee also acts as inquiring authority in terms of Rule 14(2) mentioned above, care has to be taken that at the investigation stage, that impartiality is maintained. Any failure on this account may invite allegations of bias when conducting inquiry and may result in inquiry getting vitiated. That inquiry, my lord, is related to the initial first stage inquiry. As per the instruction, when the allegations of bias are received against the inquiring authority, such an inquiring authority is required to stay the inquiry till the disciplinary authority takes a decisions on the allegation of the bias. Further, if allegation of bias are established against one member of the committee on this, that committee may not be allowed to conduct inquiry. In view of the above, complaints committee, when investigating the allegation, should make recommendation on whether there is a prima facie substance in the allegation calls for conducting a formal inquiry. They should avoid making any judgmental recommendation or expressing view which may be construed to have prejudice their view while conducting such inquiry. Now, my lord, on receipt of the investigation report, the disciplinary authority should examine the report with a view to see whether a formal charge sheet needs to be issued to the charge officer. Now, the authorities have come to a conclusion that there is no need to issue formal charge sheet because the allegations prima facie does not constitute sexual harassment. Decision has been taken, my lord, and the other decision is regarding not continuing the probation period. That is a separate thing, my lord. Both cannot be clubbed together. And whether the executive director has power or not, my lord, to that, my lord.
See, that is one part, isn't it? Regarding whether to proceed or not, the decision-making process, that you'll have to satisfy the court.
My lord,
The other part is regarding not continuing with the probation. What do you say on that?
that, my lord, the executive director has authority, my lord, if I may point. out.
No, court has already passed an order saying that you cannot be associated with this.
My lord, that is relating to disciplinary proceeding for the ICC complaint, my lord. That is not that discipline. What has been done now is discontinuing the probation period. That is a separate thing, my lord. It is not related to this. It cannot, both cannot be clubbed together. That is based on her performance.
Performance also has been demonstrated.
Page 83.
During this tenure, her work and conduct are good and integrity was beyond doubt. This was in October 2023.
Yes, today is 25, my lord. My lord, actually, there was an extension, my lord. The probation period had already over. Actual probation period is over. Extensions were given again to improve the conduct, and the notices were given, my lord, that I will produce the records. The notices were given to improve the.
See, extension was given for additional period of 6 months,
Yes,
starting from 2nd of
Seven.
July.
yes.
6 months is yet to finish.
So 24, my lord, that is
25,
page 80.
page 85. And somehow it has been clubbed together with or till completion of the ongoing deliberation of governing body on the matter of our complaints.
My lord, after that, only decision was taken. After the High Court order, my lord, the governing body came to a conclusion that it is not a fit case to proceed. No formal charge sheet should be required.
You see, we'll do one thing, you file a response, okay?
My lord.
Till then, you don't take any steps.
Yes.
Part Mr. Ken Chaudhary, learned senior counsel, assisted by Mr. S.P. Sharma for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the decision of the governing body dated 7/8/2025, bracket annexure 15, as well as the notice of termination of service given to the petitioner dated 22/8/2025, bracket annexure 17. To stop, the learned counsel, senior counsel submits that the petitioner had earlier approached this court by filing WPC number 2316 of 2024. On the ground that the respondent authority concerned had declined to accept the finding of the Internal Complaints Committee. Stop. Case of the petitioner is that the petitioner is working as assistant professor in the Department of Pediatrics at All India Institute of Medical Science, Guwahati. And she had filed a written complaint on 17/8/2023 of sexual harassment at workplace against respondent number 6. So although the Internal Complaints Committee had indicted the respondent number 6 by submitting a report, the same was not accepted. Stop. The writ petition was disposed of by order dated 5/6/2025. By interfering with the impugned communication dated 4/4/2024 to be not sustainable in law, as it was issued by an authority without jurisdiction. Stop. It was further observed that if the governing body assumes the role of a disciplinary authority, the respondent number 5 should not be made a part of the same, and his place be taken by any other officer of equivalent rank. Stop. However, pursuant to the said direction, the governing body, AIMS Guwahati, had taken the impugned decision dated 7/8/2025. Closing the complaint of sexual harassment against the respondent number 6. And had also issued notice of termination of service to the petitioner. To stop. The said notice has been issued by the respondent number 6. Respondent number 5. Of the learned senior counsel submits that the same is clearly in violation of the court's direction at paragraph 20 of the earlier order dated 5/6/2025, passed in WPC number 2316 of 2024. Of the learned senior counsel also submits that the impugned action has been taken apparently in view of the complaint submitted by the petitioner against the respondent number 5.
6.
Good.
Complaint against respondent number 6.
5.
5 is the executive director.
You said
Complaint
PMO.
was against the head of the department, respondent number
You
6.
said complaint before the PMO.
Yes.
That was 5.
No, that was by petitioner. Against my lord, respondent number 5 and 6.
Okay, against respondent number 5 and 6 before the Prime Minister's office. On certain mismanagement and mismanagement of funds. Full stop. He also submits that as per the experience certificate issued to the petitioner by the competent authority on 27/10/2023, she her work has been found to be good, and the conduct and integrity were also found to be beyond any doubt. Stop. Not only this, where is that provision?
Page 78, Mr.
No, regarding that opportunity should be given.
Oh, yes, yes. Page number 137. Para 7 of OM dated 4/11/22.
Not only that, the learned senior
Yes.
counsel submits that as per the office memorandum dated
11/3/2019.
11/3/2019, a probationer who is not making satisfactory progress has to be informed of his or her shortcomings well before the expiry of the original probationary period, so that he or she can make special efforts for self-improvement. To stop the same having not been followed, and on the basis of the same has not been followed, the learned senior counsel submits that the impugn notice of termination cannot be sustained. Next, para in view of above, issue notice of motion returnable by 3 weeks. Mr. Gupta, what is the initial? Mr. H. Gupta, you are the standing counsel? Oh, okay, Mr. H. Gupta, learned standing counsel. Learned CGC accepts notice on behalf of respondent numbers
1, 2, 3, 4, and 7.
1, 2, 3, 4, and 7. 4 also.
Yes, my lord. 4, the committee under the name.
1, 2, 3, 4, and 7.
6 are by name. So, my lord.
Petitioner to take steps for service of notice upon respondent numbers 5 and 6 by registered courts with a review, as well as by usual process. Next para, having regard to the projection made by the petitioner, it is provided herein that till the next returnable date, the impugn notice of termination dated 22/8/2025 shall remain suspended. List the matter again on so and so.
With the returnable date. We file affidavit.
Give a date 22/10. Respondents shall make an endeavor to file a counter affidavit within the next 3 weeks, so that an endeavor can be made to dispose of the case finally on the returnable date. This is from there.
Please, my lord.
Yes. You are for the petitioner. You are for the petitioner.
Yes, my lord. Indeed.
Yes.
But the pleadings are complete in this matter. However, there are 2 things that I wanted to point out, if my lord would permit. In this matter, my lord, about a week ago, and we had moved it for the The only difficulty is, my lord, this matter will take at least 1.5 hours to argue, my lord.
There's some audio issue. Your voice is breaking at times.
Is it better now, my lord?
Yes.
My lord, I'm saying we had moved a memo for mentioning on last week to have this matter listed, and we had moved it for 3rd of September, my lord. Somehow, my lord, the matter has come up today, and the only request is this, my lord, because I'll take about 1.5 hours. It's for final arguments now, my lord. If my lord can have it on some very short date, if possible, 4th of September, I would want to physically argue it, my lord. That's number one. That's my first difficulty, my lord, because all arrangements were done for 3rd, my lord. But, I mean, if still my lord would want to hear, I have no problem. The second thing is also this, my lord, there was one application for impediment that we had filed, my lord. Some of the similarly placed applicants had to be impeded. Last time it was not on record, it is on record today, my lord. IA 2359 of 25.
Yes.
So, my lord, these are similarly placed applicants as the petitioners, my lord. If my lord would be kind enough to have it only on 4th, I will physically come and argue, my lord, and this memo of parties will also be filed by tomorrow so that the matter is ripe for final arguments, my lord. Last occasion, the state took time. We do not oppose, my lord, in all fairness. If 3 days accommodation can be granted, my lord, it just I'll be in a better position to assist my lords.
What is the issue involved
The
here?
issue is this, my lord. We are all contesting for government teachers, my lord, as per an advertisement of the state government. Thereafter, there was some ineligibility that came in because of a Supreme Court judgment which was misread by the learned states. Then there were some applications and review petitions filed before the Honorable Supreme Court, in which the Supreme Court clarified that we, the petitioners, are eligible to take part in the process for teachers' recruitment. We are all diploma holders from an institute called NIOS. The Honorable Supreme Court then clarified in December 24 that all of us are eligible. The benefit of that order was given to all across the state, because it was a confusion across the country. So all states have given similar benefits to petitioners like us. After the Supreme Court order, my lord, where Supreme Court laid down 2 conditions: one, that we had to be in service as a specific date, and we had to complete the diploma. If these 2 conditions were fulfilled, then we are eligible to participate in the ongoing process for government teachers. Now, the Honorable Supreme Court did not lay down that what should be the mechanism of verifying whether we were in service or not. Thereafter, my lord, a writ petition before this Honorable Court was allowed in terms of the Supreme Court order. Immediately thereafter, the government has released a circular. The subject matter of the present writ petition is this circular. The circular, my lord, will find at page 54. This circular is impugned, my lord, in this writ petition, wherein some additional documents, my lord, which were not required from day one, had been sought by the government, my lord, without any basis of power or authority in any provision of law, my lord. So therefore, all that we are challenging in this writ petition is that at page 54, they have asked me for 8 documents. None of these documents, my lord, were required at a previous time. None of these documents the Honorable Supreme Court lays down. None of the documents the NCT lays down, which is the rightful authority, my lord. And admittedly, my lord, but state has stated in their counter, there is no source of power to ask for these 8 documents. So all that I would want to assist my lords with is that why should these 8 documents be called for? Specifically, when similarly placed applicants like me, we have been recruited in 2019, 2021 also, and none of these documents were ever called for. Similarly placed candidates like me have also been recruited 2 months back as per the state ODL system. These documents have not been called for. And I will show from the records, my lord, that these documents were not required in 2017. My enrollment for the course was as per 2017 notification of the Government of India. The Government of India had put the onus on the government to verify whether I was in service or not. I will show, my lord, each and every document. So after that 8 years, my lord, 7 in 2017, when the onus was put on the government, today the government falling back and saying that please give me those 8 documents is completely arbitrary, is my case. Plus, there is no source of power to it. And the third aspect is, my lord, because 8 states, I say this with responsibility, because I had the occasion to assist honorable different high courts as well as the Honorable Supreme Court in the very same matter. 8 states have implemented the Supreme Court's order without asking for these documents. That is very, very important, because it was a central government notification, central government scheme applicable across all states across the country. All the states except the present one, my lord, have implemented this without asking for these 8 documents. So therefore, what I'm trying to say is, my lord, that whether the state can ask for these additional 7 documents, which were never from 2017 till today in picture in any manner whatsoever. In addition to that, as I said, the state in the counter has not justified the source of power. That what power do they have to ask for these 7 documents? And I fairly squarely, I'm sorry, my lord.
All right, Mr. Saikia, what do you say? We'll have it on a hearing
Very
date.
simple. It is a very short issue. This notification which they have challenged was issued on 17th June. And if it is pleased to see the judgment, only one paragraph, page 624.
No, Mr. Saikia, what I'm saying is that the learned counsel on VCS says that he would like to argue physically in a physical
Very
mode.
nice.
So let us have it on Thursday on a hearing date.
Lordship may only do one thing. I am game for that.
Hmm.
If Lordship is pleased to take the order dated, this was the interim order which was passed.
30th June was the first order, and then it was extended, my lord, on 30th of July.
2025.
Yes.
Here, Lordship will kindly come to paragraph 11. Upon considering the submission made by the learned counsels for both sides and considering the entire facts and circumstances of the case, it is seen that as per the order of the Honorable Supreme Court passed in the case of so-and-so, the qualification obtained from NIOS shall be treated as valid for all intent and purpose, provided the candidate was in service on 10/8/2017 and having 18 months DLE from NIOS. But from the notification which is under challenge, it is seen that as many as 6 numbers of documents were asked from the candidate for verification along with 18 months DLE certificates and mark sheets to NIOS of the applicant completed on 1/4/2019. Thus, from the notification, it is seen that those some list of testimonies documents were sought from the candidate, but it cannot be held that there was any apprehension that the cancellation of candidature of the present petitioner. Further, the completion of verification also may take some time as submitted by the learned counsel, Education Department. Thus, at this stage, this court is of the opinion that there is no necessity of suspending the impugn notification dated 17/6/2025 issued by the Director of Elementary Education. However, results of verification may be kept in abeyance till returnable date. So we have completed the verification now, and we are very soon we are completing the recruitment process also, subject to clearance from this honorable court. There are 137 writ petitioners, and they are also filing some implement. 32 that Lordship has not considered till now. So
As implement as new petitioners.
new petitioners, the total 137 plus
32.
38. So what will be the total figure? About 169. So by keeping 169 posts vacant, let Lordship give us the clearance to go ahead, because their right will be protected, and they can argue the matter on Thursday. Because we want to continue with the process, and there is an attempt on some vested interest to derail the process of recruitment. There are about 5,000 posts.
What is the figure?
169.
169.
Their interest is protected. So I don't think they have any further demands. So let us go ahead with the rest of the 5,000 candidates.
But we're talking about Thursday. Today is
Thursday,
Monday.
Lordship. On Thursday, I'll argue. No difficulty on that. Let us go ahead, Lordship.
No.
Because I know what can happen on Thursday also. I can foresee,
No, that could be done also, but why segregate at this stage?
Lordship.
Why
Because I'm
segregate
giving my
at this-
undertaking. It's my personal undertaking that Thursday I will be available to argue, my lords, without any excuse. In fact, after this, the matter also came up on 30th July where the
Lordship,
government sought time.
First item on Thursday. No.
Very well, absolutely no
No.
problem.
If something happens on Thursday, then we'll see that 169 was not filled up. You go
No
ahead.
difficulty. I have made my position clear.
Because if matter can be taken up on Thursday,
Yes, yes.
then why segregate, give
Only
some
thing is
post,
that,
go ahead with
because
some
these
post.
137 candidates, why rest of the recruitment process should not go ahead? Because we have completed the verification. We have to streamline the select list now. And we want to we want to give the appointment in next 15-20 days. The students are suffering.
So just have the 30th July order, my lord. On 30th July, after the returnable date, it was the government which sought time, which we fairly did not oppose, my lord. And in fact, we were in a hurry. But with all due respect, my lord, I understand, I appreciate the activeness that is being shown by the government. And I'm assuring, my lord, it's my personal assurance that Thursday, first item also no problem. Plus, my lords, we are 139 plus 32. So on Thursday, my lord can take a call instead of considering the matter today. And my lords may call for the reports. We had moved it for 3rd September. Somehow it has gotten listed today, my lord. So therefore, there's a genuine difficulty. And I'm not based out of Guwahati, my lord, or else I would have been there physically present. So all the time, I'm not even asking for a week, my lord, just 2 days, my lord. My lord, may have it as the first item, absolutely no problem. I'll ensure that we are present, my lord.
If they are successful, their position is remain intact. Their interest is protected. What I am submitting, I am conceding that we will not touch 169 number of posts.
Okay, no, it's not one. No, the question is, what is the
And how much time they want to take, there is no difficulty.
No, what is the difference in 30th July and today? Please see the 30th July order. See the last order. The government had sought time. So I am just saying that whatever is being submitted by the learned AG, with all due respect to that, from 2 orders, whatever the position has been, for the next 2 days it can be maintained. And on that day, my lords may take a call. I will argue the matter finally.
Okay, so
And-
we'll fix it then, Thursday.
Very well, my lord. Lord, the interim order,
That is my submission.
Lord, the IA may be allowed for impletement, my lord, so that we can file the memo.
Subject to lordship's convenience.
IA, let us see.
Plus
Any
2,
objection to the IA?
For implement.
Yes.
No.
Okay.
2359 or 25, my lord. Whereas 7 we have stated, my lord, they are similarly placed.
How many applicants are here?
My lords, in the IA, there are 32.
32.
In the original matter, they are 139.
What is your good name?
My name is Mandeep Kalra, my lord.
Heard Mr. Mandeep Kalra, learned counsel for the applicant through RVC, who submits that by filing this application, the applicants seek implement of additional implement of the 32 applicants as petitioner numbers
140, my lord, 140 onwards.
142,
171.
171. Since they are also similarly situated and the outcome of the writ petition would have a bearing on the interest. To stop, the learned counsel submits that by impleting the applicants, the same would not change the nature and character of the writ petition, main writ petition. To stop. Next para, Mr. D. Saikia, learned advocate general Assam, appearing for the state, clearly submits that he has no objection if the IA is allowed. In view of above, the application stands allowed as paid for. Then what about your implement? Your cost title?
So by tomorrow, we'll do it, my lord, 100%. The amended memo parties will be filed by tomorrow. The cost title amendment will be done by tomorrow, first half, my lord, without fail.
What about this IA 2555? What is this? Your implement as petitioner, as what? Respondent? As respondent. So how will your right be affected?
Because this IA, we may have some objections. If my lord would want to consider, my lord may issue notice, we'll file a reply if my lord would want to consider. But as an officer of the court, I feel their right is not impacted in any manner.
Is precisely the reason why I said modification of the interim. There will be some ploy from either side, you don't know, which will delay the whole process.
I'm sorry, my lord.
I am easily saying that no objection from our side. Now, one side is saying that there is objection regarding.
No, Manoj, I don't know. These people are not similarly placed as the applicants. If they want to implead as a respondent,
So that
I
is
don't know
why
how is.
keeping their interest intact, Lordship, they modify the order, then.
No, I'm sorry,
whatever
Manoj.
time they want to
Please
file
don't put.
objection, further objection, I have no option.
My lord may consider on the next day whether they're important. In my opinion, they're not important in any manner because they're not similarly placed as me. If they're agreed, they can file an individual writ petition. And I am not nowhere connected with them in any manner, my lord, whatsoever. I'm sorry, the learned lady should not put it on the petitioners for any reason, my lord. That's not, we are not connected to them in any manner whatsoever.
This is a bit different, isn't it? Applications for impleadment as respondents, isn't
And
it?
this concept is unheard of, my lord. Why would a private parties want to implead as respondents in a writ petition?
You could very well file a separate writ petition. Why do you want to be pleaded as a respondent? So let it be pending. Will not issue anything. In view of the order passed today in IAC number
2355. 2359, sorry. 2359 or 25.
2359 of 2025. The petitioners shall file the amended course title
By
in
tomorrow.
2 sets within 2 days. Full stop. As agreed to by the learned counsels for the rival parties, list this matter for admission hearing on 4th of September.
This is one short request, my lord.
Yes.
The interim order may continue till the next date. Twice it has been continued, my lord. Hopefully for the last time it may be continued.
As the first item in the admission call. Interim order passed earlier shall continue till that next date of listing.
Highly applied.
I'm so deeply grateful, my lords. Deeply grateful.
Lordship, kindly pass over the matter for the time being.
What is this matter? Let it come some other day. You can't pass over at 4 o'clock than that.
Not on any day except 2nd of September.
What is this matter?
Well, they are filing another IA, my lord.
IA for what?
IA for keeping some post vacant for another advertiser, not this advertiser.
Where's the counsel?
The court number 6.
Lordship will fix it any other day except 2nd.
After a week. This matter again after a week. On a date to be fixed by the registry.
May it please your lordship. In respect of item number 48, lordship, there is an interim of Petitioner.
Interim order passed earlier in WPC number 5163 of 2024 shall continue till the next date of listing. What is the interim prayer? What is the interim order?
To keep the vacancy of one post.
May I please your lordship? Lordship, in item number 46 and 47, lordship. In 47, they have filed, respondents have filed their objection, lordship, and we want to file a rejoinder, lordship. So 1 week time may be given, lordship.
One more line you write like this. Parties are at liberty to exchange pleadings in the meantime. Okay. Yes.
Much obliged.
Please, your lordship.
Yes.
Lordship, regarding this matter, there's a law court's order. We had to take steps. Because of respond number 6, the service has been completed.
Upon perusal of the Lavazima Court's order dated 4/8/2025, notice upon the respondent number 6 is accepted to be complete. List the matter under the admission column after 2 weeks on a date to be fixed by the registry.
Obliged.
May it please your lordship.
Yes.
My lord, this is a very peculiar case. My lord. What had happened? The petitioner was appointed by the governing body of the college in the political science department. Meanwhile, my lord, the post was advertised to which the petitioner applied. Now, my lord, on the ground that his PhD degree is not valid, that was the ground taken. Eventually, my lord, now what the director has done, my lord, he has re-advertised, he has given and issued an order for re-advertising. Now, my lord, we approach this honorable court that this honorable court by interim order dated 25/10/24 was pleased to issue notice of motion and my lord, re-advertisement was stayed. So that is how the matter stands. Now, my lord, this suspension order has been issued. Kindly take the IA, my lord, page 14.
Yes, 14.
Kindly come to page 14, my lord.
Yeah.
As per GB resolution number 6, dated your service in the political science of so-and-so under temporary is hereby suspended till the final verdict of the court case submitted by. What is this, Miller?
Which court case? Verdict.
This is the court case.
Now, where's the WPC?
I do. Hey, order. WPC record. Kindly have a look at order dated 25/10, Miller.
What is this writ petition filed for?
Writ petition was filed, Miller, challenging the order passed by the Director of Higher Education, whereby my claim for appointment was rejected and the post was advertised. Direction was issued for re-advertisement.
And what have you done in the meantime? You earned suspension.
No, Miller, otherwise, even if supposing I am not regularized also, but I'll continue as Millard contractual. It's not that somebody else has come in, so therefore I needs to be replaced.
Oh, your service has been suspended.
Yes. So this is not the purpose of suspension. Power of suspension has been invoked for wrong reason. As such, Millard, we are getting hardly anything, Millard. We're just getting a small stipend. Power of suspension is not for these purposes because writ petition is pending. It's not that there is any allegation against me. A DP is contemplated. I think, Millard, this order is wrong, Millard. Since will kindly stay that on.
Selection of the petition on the post of assistant professor is please write down not Mr. Ken Chaudhary, learned senior counsel, assisted by Mr. M. Das for the applicant who submits that the applicant had filed WPC number 5395 of 2024 for setting aside the speaking order dated
There is no date, Millard.
bracket dated nil
And
issued by the Director Higher Education, Government of Assam, whereby the selection of the petitioner to the post of assistant professor in political science at Bausi Banikanta
College.
Kakati College had been rejected. And whereby the college authorities have been directed to issue fresh advertisement
Yes.
for filling up the post. So of this court, while issuing notice of motion on 25/10/2024, had directed in the interim that the post of assistant professor in the Department of Political Science should not be advertised till the next returnable date. To stop the said interim order continues as on date. Stop the learned senior counsel submits that now the principal of the college has issued an order on 6/8/2025 purportedly pursuant to the GB resolution number 6 dated 27/3/2025, communicating the petitioner that his contractual service is suspended till final verdict of the court case submitted by him. Stop the learned senior counsel submits that the contractual service of the petitioner applicant cannot be suspended in such a manner. And the same should be stated. Who is appearing for the respondents in view of above?
Hello, I am appearing for higher education department.
Issue notice.
Therefore, the government responded.
Issue notice returnable by 3 weeks. Your good name, Mr.
Yes, sir.
S. Das, Learned Standing Counsel.
Higher education.
Education accepts notice on behalf of respondent numbers
1, 2, 3, 4.
1, 2, and 3.
1, 2, 3, and 4 also.
4 also. 1, 2, 3, and 4. And Mr.
Yeah.
K.
Yeah.
Mr. K. Ahmed, Learned Counsel accepts notice on behalf of respondent number 5. Petition applicant to
5 and 6, my lord, college and 5 and 6, I think my learned friend can have.
5 and 6. Okay, 5 and 6, okay. Then applicant to serve notice upon respondent number 7 by registered post with a review within 3 working days. Having regard to the rejection made by the applicant, the impugned communication dated 6/8/2025 shall remain suspended till the next returnable date. List the matter again after 3 weeks on a date to be fixed by the registry.
Continue to returnable record. The earlier interim order in the writ petition will be continued till they appear. It has not been listed. No? Service is not complete, that is why.
Yes, main writ petitions are not listed today.
Not listed. It will be done when it is listed in.
As and when it's listed, you remind, we'll pass
Yes,
the
yes.
audit. None appears for the petitioner when the matter is called. Stop. Same was the case when the matter was listed on 18/6/2025. The writ petition stands dismissed for non-prosecution. Interim order passed earlier, if any, stands vacated.
May I please your lordship, my lord? Now, the matters relates to non-payment of salary and pensionary benefit. The petitioner was, my lord, retired from service, my lord, and attaining the age of superannuation on 29/2/2016. And government is, my lord, taking time. And on the last occasion also, my lord, they took time. I order dated, my lord.
Today, there's nobody to take time. Huh?
I am suffering, my lord. My client is in bad lying, my lord. At any moment, he may collapse, my lord. He's suffering from, my lord,
Who will collapse?
my client.
Or your client will collapse?
He's in the hospitalized, my lord. They did not pay any salary, my lord, since the date of appointment. I was, my lord, regularized in service after undergoing training as per the direction of the court. Then, my lord, I continued my service. I attained my lord, superannuation. And matter relates to, my lord, pension, service benefit and salary.
Matter relates to pension.
Yes.
Why?
It may not, they are to clarify the position, my lord. They didn't bother even to appear and obtain instruction, despite specific order passed by the court. On the last occasion, my lord, they took time to file affidavit. on 6/6/2000, my lord, 25.
Yes, anyone appearing? No one. There are two pegus there. Which one?
Second one.
1 week time. 1 week time.
Yes.
P.N. Sharma.
Yes, sir.
Mr. P.N. Sharma, Learned Standing Counsel, Elementary Education Department, is said to be preparing the counter affidavit on a prayer made on his behalf by Mr. G. Pegu. Matter stands adjourned for 1 week.
Yes, can you treat the matter on 18?
List the matter again after a week on a date to be fixed by the registry.
All right.
In this matter, my lord, I have to file a reply to the affidavit in opposition, my lord.
How
Can you
much?
allow me some time, my lord?
How much time?
My lord, let the matter may list after entering vacation, my lord. I'll
Finances
reply to-
filed their affidavit. To that, your lordship, they have taken time to file rejoinder affidavit in reply.
let the matter
On the
list
last
after
day.
vacation, my lord.
As paid for by the learned counsel for the petitioner, 3 weeks time is granted for filing rejoinder affidavit. So the affidavit filed by the finance department. What?
Finance has already filed affidavit.
Oh, that's what he wants to file rejoinder.
Yes, sir.
You have filed affidavit.
Secondary education.
Have you filed?
No, our affidavit is not yet filed here.
You will be filing or not?
It's not necessary, your lordship.
List again after the ensuing puja vacation.
Oblige, your lord.
Keep your breath.
So in this matter, today I filed our affidavit in reply against the deputy filed by the respondent.
Like what?
Petitioner, counsel for the petitioner submits that he has filed the rejoinder affidavit today. Full stop. However, it is seen that the same is not available on record. Office to verify and list the matter again after a week on a date to be fixed by it.
Give you.
I would like to file reply, my lord. Take a file one affidavit.
How much time?
2 weeks time.
As paid for by Ms. K.
Stamp that.
Ms. K. Devi, learned counsel for the petitioner. 3 weeks time is granted for filing rejoinder affidavit. List again after 3 weeks. Ms.
Keep
P. Das appears for the secondary education department.
I'm appearing for second.
Yes.
Here is a case, your lordship. I have been granted provisional pension pending judicial inquiry proceeding, your lordship. But your lordship, kindly see the allotment order, page 67, your lordship. Last page, page 67.
Yes.
I have been granted provisional pension of only rupees 27,500. Now, your lordship, if your lordship, can you see, my gross salary was, your lordship, 2,38,721, and my net salary was 187. That is reflected in page 41, 47, and 51, submitted by the principal of the college, your lordship. Your lordship may kindly see page 41. So it is a only dispute, your lordship. They have filed a response, but they have stated nothing against this, your lordship. They have stated about the period of suspension, to which I have clarified by submitting my reply. Your lordship may kindly see page 41.
Yes, what is 41?
Page 41 is the check slip where in the principal has stated the last pay drawn. There is the net pay. Page 41.
Yes, where?
Under 18, is clause number, serial number 18. My net salary was 1,84,550. Then again, it reflected in page 47.
page 47. Your lordship got it.
You have retired from service.
Yes, I have retired long in back in
So
2019 October, your lordship. I am getting only provisional pension of 27,000.
at the time of your,
At least be 50% around
Ah.
1,000, your lordship.
at the time of your retirement,
Yes.
your gross salary was 184,550.
Yes, yes.
Okay, what
So
is what is 47, page 47?
Page 47 is also the gross salary is given, a net salary under the serial number 10, November 2019, 1,87,300. Then it was again reflected in page 50. 50 is the gross salary. Page
Okay,
50, page
okay.
50.
They have filed the counter affidavit.
They have filed, they have stated nothing about this. They have stated about what is my period of under suspension that I have clarified by submitting my reply.
Lordship, the
Not
reply,
on
we have
the
not received
amount.
a copy of the reply, Lordship. And moreover, the reply is filed by one Lordship, Sahadur Rahman, Lordship, not by the petitioner, Lordship. The affidavit in reply, Lordship.
Reply.
Yes,
No, that was submitted because, your lordship, at that time I was in judicial custody in the judicial proceeding. That's why. I have written that I am the son of the writ petitioner, para 1, 86. Have you not read it? That I am the son of
Read
the.
the whole paragraph.
Yes.
Where?
I am the son of the writ petitioner of the above mentioned writ petitioner and presently is the petitioner, and I am fully conversant with the fact. Yes.
So,
Lordship, I have not received the copy of this.
you have not received.
Moreover, Lordship, certain instructions.
Then how do you know that you have not received that it was filed by somebody else?
Lordship, I have seen the second copy, Lordship. Yes.
I have written in your lordship,
Lordship, in our affidavit, Lordship. it's
30/11,
certain
2019.
instruction, Lordship. In our
30/11/2019, I have retired, your lordship.
Yes.
It is almost 6 years, your lordship. In their affidavit, your lordship, they have now stated nothing about the quantum of the provisional pension. They have not disputed. They have only stated what is the period under my suspension. That is irrelevant question that I have also clarified in my reply.
No, your period of suspension has not been regularized. Or what? What seems to be the problem?
That is not the now issue. They have already granted, after taking into consideration every aspect, they have granted provisional pension as per the direction of this honorable court, your lordship.
No, provisional pension is only temporary.
Yes. So even the temporary, that is quantum is very less, your lordship. Gross salary is 2 lakh something.
That is
Yeah.
why I'm asking why they have not given you the 50% of your last paid salary.
Exactly. They are not answering on that, your lordship.
Mr. Upamanya?
Lordship, I'll have to file a counter to this reply, Lordship, because it
They
has
have
been
already
filed by
filed.
his son, Lordship, and there is no authority, Lordship, and no, even if he is in custody, Lordship. he should
No,
have filed a
no.
wakalat number.
See, those things are different. Whether
This is
XYZ has filed, son has filed, daughter has filed, not. We're talking about the pension.
Yes, Lordship, for that, Lordship.
See,
now
pension is not a bounty, okay?
Yes.
Now, his gross salary at the time of retirement is 184,550.
No, 2 lakhs something, gross. Gross page 50.
To that effect, Lordship. in
Okay,
our-
gross is 2 lakhs, okay,
2,38,721.
okay. Then you are giving him only how much now?
Your lordship,
provision.
they are paying me
27,500.
27,500.
Lordship, for that, Lordship, we sought for some clarification from
How
the
long can you give like that?
Even that is paid after first round of litigation, your lordship. As per the direction of this honorable court, contempt has been filed there, then and thereafter. It is nothing absolute and arbitrary action, your lordship. Now they are relying on something, son. Where is the bar? The son cannot file an affidavit.
I have not-
Whether Wakaladam is required. Have you gone through?
Lordship, that instruction which we have sought for in our affidavit in opposition, Lordship, that I have not received yet, Lordship. We have sought for some instruction from the department, 2 departments, Lordship.
You have sought for instruction by way of affidavit in opposition.
No, Lordship, that we have placed before this honorable court, Lordship, and thereafter, that same was thought to have been brought on record, Lordship. So we have filed our affidavit, Lordship. And then, Lordship, certain instruction were asked for from the APSC and the principal, Lordship.
Where is that?
Lordship, at page 73, Lordship.
You have already filed an affidavit.
Yes, Lordship, at page 74, Lordship.
The director,
ASP,
parent
Lordship.
department, parent department. affidavit by the parent department. Respondent number 2. The provisional pension is to be paid by the parent department.
Director of Higher Education.
Yes, the parent department.
What do you want
So,
to show?
Lordship, that instruction is still awaited, Lordship.
Which
from the-
instruction? Which instruction?
Lordship, at page 74, Lordship.
What have you written in page 74?
Current status of
What?
Suspension.
Yes, Lordship, and the Lordship, the entering deponent also issued a letter to the principal to clarify as to why in pension paper of Hamidwe, ex-associate professor, Guwahati College, it is certified that he had retired from his service on 30/11/2019, whereas in their forwarding letter, it is specifically mentioned that Hamidur Rahman was released from service with effect from 9/2/2011, and he did not come back to college. Lordship, that instruction from the principal we are yet to receive.
Principal is a party?
Yes, Lordship.
No, in the instant case, principal is not the party. In the another litigation is there regarding regular pension.
Respondent number 4, Lordship.
Mr.
Yes,
Mania,
yes.
this affidavit of yours is filed in August
Yes,
2024. 1 year back.
Yes, Lordship, but that instruction is still pending, and Lordship, the principal is a party here, Lordship.
Huh?
Principal is a party in this.
He's a party.
Yes, Lordship, respondent number 4.
Whatever it may be, whether a party or no party, principal is under you only.
Now, in the checklist submitted by the principal, he has already stated that I have retired on 30/11/2019, page 40, your lordship. Page 40.
Mr. Counsel, I'm dealing with the government counsel. You just bear with me. If both of us start asking him, how will he reply?
Sorry, your lord.
Mr. Upamanya, how long can we wait?
Lordship, next week, Lordship.
Next week?
Yes, Lordship, because I do not have a copy of this reply also, Lordship, I'll like to file a counter.
No, you are supposed to get instruction.
Yes, Lordship, that also I'll get.
Page 74, what has happened to this? How long can you continue to pay the
Lordship,
pensioner like that?
Next Friday, Lordship.
Friday?
Yes, not this Friday, Lordship, next Friday.
As paid for by Mr. D. Upamanya, Learned Standing Counsel, Higher Education Department, list again on Friday next. Oh, that's why. You know it's a holiday, that's why it's taking on a holiday.
Yes.
Sorry, Lordship.
Monday.
18.
11th, your lordship.
Yes, why not on Thursday?
16.
Thursday, 11th.
16.
Okay, on 16. The Learned Standing Counsel shall obtain instructions as to why the petitioner has been only paid provisional pension amounting to rupees 27,500, while his gross salary on his retirement was 238,721. Yes.
Item 45, we have preferred on IA. Just called your lordship and I have instructed my junior to place it, to take it, mention it for the time being, my lord. But the other side is taken time. I have got urgency into the matter, my lord. Because we are students, we have appeared in the examination. We have cleared the examination. They have changed the rule of the game after the results are declared, your lordship. And selected the persons who have secured less marks.
We have passed some orders, I don't know what.
Lordship, it was for posting in the next week.
1 week.
I pray for taking on Thursday or Friday, your lord. I have got audits. Day after tomorrow may not be possible. I don't Thursday or Friday.
Have it on Monday.
On Monday, okay.
Friday, some difficulties there from the but Thursday we have picked one, some hearing matters.
Can it be tomorrow then? Only my prayer is because I.
You have it on Tuesday, you have it on Tuesday, that will come on Tuesday next.
Not here, the week I'll not be.
Hmm?
I'll not be available. This Thursday, can it be done? Orders, a small order I need to prepare. Just for keeping few posts vacant. because subsequent to the lordship advertisement issued, they have again issued two advertisements, your lordship. And there are posts and there are similar order passed by his noble court in favor of one of the candidates into that selection process, wherein lordship one post has been paid back in. So we also want a similar order. Few lordship number of posts be paid back in. Young students, your lordship, they have appeared in the examination.
Okay, okay, Thursday we'll. Just tell her. Item number 45 on 4th.
It will be fourth, my lord. Applies.
In this case, they're supposed to file the affidavit.
Lordship may kindly grant me further one back to file the affidavit. I am required to file the affidavit 45 and 6.
Has paid for by Mr. Ginath for the 1 week time.
Yes.
Is granted for filing
For
counsel.
4 and
Let's take it after 1 week. On a date to be fixed by the registry.
But a date may be given, but
I'll fix the date. I've directed, yes.
But
Yes.
Here, Lordship, affidavit is required, Lordship. The matter pertains to provincialization of services.
Yes, Ms. P. Das,
3 weeks' time may be granted to us, your lordship, to file the affidavit,
that's paid for by Ms.
as the
P. Das.
instruction is not received yet.
Further 3 week time is granted to obtain instructions and to file counter affidavit. List again after 3 weeks on a date to be fixed by the.
Deeply obliged.
Last occasion, Lordship had asked them to put in instructions, my lord, with regard to payment of this family pension and compassionate family pension, my lord, in these cases. Because these, they're the mother, my lord, of the deceased government servants, my lord. They were, my lord, provided, my lord, the pension, my lord, NPS annuity, my lord. One of them has refunded the money, but the other could not.
In this case, we have received instruction, madam. Madam may allow 2 weeks time to file affidavit.
Hmm?
In this case, we have received instruction, madam. 2 weeks time may be allowed to file affidavit.
Mr. Stuti Learned Counsel, Standing Counsel,
Elementary.
Elementary Education Department submits that she has received the instructions and prays that she may be granted 2 weeks time to file the counter affidavit. Praise aloud. List this matter again after 2 weeks on a date to be fixed by the registry.
Can I prefer date, since the pension matters, man?
They are fixing a date, okay? I'm not giving a date. They'll fix a date.
Fine.
Within 2 weeks he'll come.
Manoj, matter relates to suspension matter. The petitioner of Lordship was placed under suspension on 17/3/2025. Till date, Malad, no DP has been initiated. So, Malad, as per other Chaudhary's guideline, Malad, the petitioner will be reinstated to practice.
PTC.
Last order, Lordship, kindly pay.
Lordship, in this case, Lordship, some instruction I have already placed, but I have not yet filed my affidavit. In fact, Lordship, I have not received Harassment.
Matter of
Okay, anyway,
suspension matter.
what about suspension? How long can you keep this person?
Only instruction I need to place, Lordship, whether the suspension was reviewed or not. That's my problem.
Malad, that order I have got.
What?
They have reviewed the order. Lordship, kindly see the review order, Malad.
If
Let's say no DP has been initiated. Without DP, even if they review, the suspension cannot be continued. First, they have to initiate the department proceeding, then only question of review will come. And only because the pendency of the petition, they are continuing with the suspension. That is the only reason they have given in the review order.
Exonerated by the High Court.
my lord.
Which case? This case?
This is the writ petition, my lord. Because of pendency of the writ petition, they are continuing with the suspension order, my lord. There is no reason as to why the suspension is extended. But my lord, no DP has been initiated. They have to first initiate a departmental proceeding, then only question of review will come.
Show it to Mr. Naik. You have a look, please.
I have not yet accepted. No,
You have a word with the authorities.
at least in this case, Lordship will not exonerate him in a POSCO case. No.
No, exonerate means they say the
In the criminal case.
no. Till he is fully exonerated by the High Court. POXO case is pending in the High Court.
No, my lord.
No.
Then
That is
It
the
is the
understanding.
trial
This is
stage,
the
my lord.
difficulty now. Lordship will understand.
He
Lordship,
was
so
never
far as-
arrested.
So far as
In
his
fact, he
present
was
case
never
is
arrested.
concerned, so definitely he was suspended after getting arrested by the police and
No.
remaining in custody for more than 48 hours, right?
No, no arrest. He was granted bail by the honorable court, my lord, because he was not involved. Only now trial is going on.
Lordship will grant me some time. I
you
have
take it
to-
up next Monday. You bring your instructions.
Monday.
Monday.
Not 1 week. Lord.
Monday is 1 week.
Today's Monday.
Today is Monday. Monday to Monday is 1 week. On the prayer of Mr. P. Naik, Learned Standing Counsel, PTC, 1 week time is granted to enable him to obtain instructions.
Only question arises, my lord, whether.
With regard to the prolonged suspension of the petitioner. You keep this with you, produce that on the same day.
My lord.
Ms. P. Das. You were running away, then now you are appearing.
He is afraid of PTC, my lord.
Ms. P. Das, Learned Standing Counsel, Secondary Education, appears correspondent numbers 1 and 2, is it?
My lord, I am appearing for resolution number 6.
Your good name, Mr.
Came 6.
A. Hussain, Learned Counsel, appears correspondent number 6.
In this case, madam, there is a urgency, madam. Let the matter be listed Thursday, madam. Because in this case, madam, the school is running since 2004, madam. But this time, 2005, the government director not allow us to open the hotel, madam. There is a in 11 and
But
12 class, madam.
They have not filed any
The
counter
student
affidavit
did
also.
not get the admission, madam, in the first year higher secondary class, madam. 33 0. And it is fixed for instruction, madam. Earlier, Mr. Petitioner was,
I have received instruction here, my lord. Here it is stated that the school is running without feasibility report and government permission. And moreover, in our Act 2017 and amended in 2018 under section 311, that cancer education institution which have been established and had obtained the required permission, recognition, affiliation, concurrent, as the case may be, up to the last and highest class required for the concerned institution from the
Okay,
respective
why don't you file that? If you have received the instruction, file your affidavit.
it
My
is
lord,
not
I
instruction,
think-
madam. This is a letter, madam.
I
And this school is running up to
instruction is required here.
2024. This time they are not allowed us to get admission of this first year of this 11 class, madam. That is my case, madam. And this honorable court has already been passed an order, madam. Actually, this order also covered, but I would like to argue this case. So next week, madam, next week, fix a date, madam. Because
So-
the student won't be able to get admission, madam. This is to August has gone.
My lord, in our instruction, some.
The
clarity
school
was
has been,
required and,
the school has been running up to 2024. Nowadays,
I
stated
get
that there is no feasibility report. What is this going on?
So,
And always
so
they
my lord,
take
I
my
have to
it's just a sheet, my lord, and place before your lordship and stated that this happened, madam. What is this going on, madam? It's a very unfortunate, madam.
Let him
Madam,
get
I
in.
have to obtain, I have to obtain instruction from the department, madam. So, madam, sometime maybe granted
then-
and And
10 days may be given out.
in this, so that we have to file our affidavit here.
And there is a two section, my lord, in this case. My lord,
Which means we
science
understand it
section is going on.
matter of 2025, my lord.
I have come for to open the portal here, portal only. And that portal has been closed this year only. Since 1996, we are running this school. Now they stated that there is no feasibility report, something blah, blah, blah.
And as per my instruction, it is stated that there is no feasibility report and government permission here.
They're just stating everything.
Anyway, whatever your stand it is, you file that in affidavit.
Yes.
Isn't it?
No, let them bring instruction, madam. Let them bring instruction why they have been closed the portal, madam. Why they have been closed the portal this time? Because there are two sections. Science section is running, my lord.
My lord, regarding the
unfortunate.
portal,
And students are
higher secondary
also-
council is the authority who operate that portal, Darpan portal. And
Okay, for the well, a shortage may be given, madam. At least otherwise the student will be suffer, madam. That because of portal, madam, they won't be able to running the 11th class, madam. There are two section 11 and 12. They are not provincialized. They got permission from the authority in the year 2005. We have applied 1995, madam. Then 1996 cases. This school has been running up to 2024, madam.
What
But
kind of-
only 25 they have did not allow us to open the portal. Madam.
Okay,
They did-
what
did-
kind of school is this? What
This
kind of
is a high secondary school, madam.
secondary school?
Yeah.
First
Yes,
year
madam.
class means what? Class 11?
11 and 12. Yes, 11. They have been closed the portal.
Since when?
2005, my 2005.
2005.
Yes, my lord. 6 May to. I'm sorry, my lord. April 2025.
Or 25?
Yes, 25.
2005. That's what.
Only high secondary first year. Second year is going on.
my lord, regarding
And
the
science
system
section
opening of
also.
Darpan portal, the Assam Higher Secondary Council is required, my lord. Yes.
No, Assam High Secondary Council already been submit before lawsuit that this is they are the main authority. Director is the authority to give permission. Without give permission, they won't be able to. This is the submission by
So,
the.
my lord, sometime maybe given, I will take the instruction regarding that, my lord, permission.
No need to file affidavit in this case, madam. Why they have not been opened the portal or why? That is the question, madam.
And as per High Secondary Council, regarding the opening of portal, that permission is required from the government.
Not government, from the director.
The director
Is under the signature of your director.
What are the
Not
petitioners? Who are the petitioners?
Petitioners are the
Teachers.
teachers. Yes, madam.
Name of the school?
Yes. Name of the school is, my lord,
Luckygons.
Luckygons High Secondary, Synopsis Para 2. Luckygons High Secondary School are two streams, science and art. Science streams are going on, madam.
Is right. By filing this writ petition, the petitioners who are teachers of the Lucky Gunj High Secondary
High Secondary School.
High Secondary School
Yes.
seek for a direction to the respondent authorities to open the Darpan portal
Portal.
for submission of application for admission to high secondary first year class,
Chair classes.
which has been closed since the month of April 2025. Mr. U. Sharma, learned standing counsel, high secondary, place for and is granted 10 days time to open instructions. List the matter again
After 10 days.
after 10 days
Give me
on a date to be fixed by the registrar.
Regarding the Darpan portal, my lord.
After
the
10 days,
opening
10,
of
my lord,
portal,
10.
That Assam Higher Secondary Council is required. And our.
Non-appears,
part is-
can you pass an order non-appears from the respondent? Or the. Here are also vital parts.
Assam State School Education Board.
Yes.
Yes.
Council.
Who is the council? They have a,
This is Shutia. There are lots of advocates.
their name is reflected.
Yes. His name is known. I neglected that.
Yes.
Yes.
In the cost list, their name has.
The learned council appearing for respondent number 5, that
Five.
is Chairman, Assam State School Education Board shall also obtain instructions in this regard by the next date. Please inform them,
Yes.
whoever the
Sure.
council is. The board, council for the board, you inform them, they also
Yes.
let them bring the instruction.
Let the matter be listed next Thursday, matter.
No,
It's
it'll
a-
come after
since
10 days, 10 days, 10 days.
10 days.
Hmm.
Yes, today is 1. This, where, September, na? 11 then, my lord? 11, my lord? 11, no?
Notice was issued, my lord, in the month of June, the last occasion, government is supposed to file affidavit.
Some more time?
3 weeks time may be granted, Your Lord.
Respect for Mohammed P. Das, Learned Standing Council, Secondary Education. Further 3 weeks time is granted for filing counter affidavit. List again after the date.
I'm deeply aware.
It's